What is
27?
27 is the Sarda Mines matter, my lord. It was specifically adjourned to today. I have intimated the other side, my lord. The information.
We are for the petitioner. So give us a
Interim
date.
order is continuing, my lord. Extend.
Still,
Yes.
there must be a date. When?
2 weeks.
Huh? Let make a mention at 2.
At 2 p.m.
Right. And
And
give a date.
Asking for 2 weeks.
Item 43 will make.
Asking for
43 also, my lord. 43 we are seeking 2 weeks time to file counter, my lord.
Let the matters be called.
Yes,
And 2 p.m.
Lord,
2
Lordship,
p.m., yes.
taking pardon.
In fact, it becomes very difficult when we adjourn fixed matters,
My lord.
and it becomes difficult for the inconvenient for the lawyers also.
Lordship, taking pardon to mention one. Lordship, taking pardon to mention one appeal. Lordship, 2 weeks ago also I had mentioned, and my Lordship had directed for its listing. Lordship, it's a criminal appeal. It was disposed only due to non-appearance. So I am just praying for the listing of my criminal appeal. 286
All right.
oblique 15. It
Yes.
was
Send a memo afresh, giving the details.
my Lordship. I will submit today only.
Related to service, earlier it was before the state tribunal. It is arising, it arises from that. Lordship, this is a matter which is before the division bench of this honorable court. There is a difference of opinion. That too, then it has been referred to a single bench of Honorable Justice B.R. Sarang. So, my lord, I'll ensure. Lordship.
Matter minding has been continuing.
Lordship, item 42 on your Lordship board. I pray for the matter to be taken up at 2 p.m. because the matter is very urgent in nature as the petitioner was selected as the LY. However,
Mr. This mention was being made in 42, I think.
No,
43.
Yes, what is that?
the links in the matter is the petitioner was selected as the LY. However, no work order is being issued. The state has already filed the counter. Subsequently, the petitioner participated in another tender when he was disqualified in the technical way for past history of litigation. Both the matters are.
What right do you have? What right do you have? We will see. We'll take up. Counter affidavit has been filed.
Yes, sir.
Let us. Let's try.
Items for orders, item number 14.
Lord, in this case, you will also given direction to ascertain about the time taken for a new policy. We have received the letter 28 from Secretary that we want 6 months time to tell the policy.
Then we will decide.
Earlier, other that is your disclosure with direction to the petitioner to withdraw the writ appeal with the liberty to challenge the future policy.
I don't think we could have issued a direction.
Issued?
They must have asked for liberty to withdraw.
Yes,
We
yes,
could not have directed them to withdraw. We have issued a direction that
6
withdraw.
months, 6 months time is necessary that the secretary read the letter to her.
We will decide it then.
March 2025, they have started.
Why this appeal is pending?
Other writ habit says they have it
Listed separately.
disclosed.
No. Who is for the appellate? No, for the other side.
This is the earlier order passed by your lordship, the back order read.
You have only one copy?
My lord,
Only one copy you have of the order?
one copy I have.
This is by state.
Appeal by state by this order.
Different. Play.
In the case of my lord, 139.
It's not a limitation.
When will you file the certified copy? No, but it has already been
Eight.
listed earlier also.
Certificate we will already applied, within a day or two that will available by online.
Mr. K.C. Kar, learned government advocate, undertakes to file the certified copy within 1 week. Considering the said submission, the I is disposed of, full stop. The certified copy shall be filed within 1 week as undertaken, full stop. In the IR 1216, 2023. Issue notice to the sole respondent on the question of condemnation of delay by registered post oblique speed post with AD returnable within 4 weeks, requisites for which shall be filed by today is 18, by 22/11/2024. List after 6 weeks.
Month.
Date.
6 January. Item 15.
Case, there is delay of 4 to 71 days, notice was issued on limitation matter, AD not valid.
You had, AD is back. You had given, tracking report is back. You had given the address of the office. So you have to file the correct address. And do you have the file? Please check the address of the respondent.
But not asked to.
No, do you have the file?
Yes, I have tried.
Please check the address of the respondent.
Address estimate project Pradhan. Pradhan, at post, Sudoku district Kandhamar.
Found a different address. Presently working as DLR class 4. So you find out if you have not taken notice to his permanent address, please do it.
Yes,
All right. Mr. K.C. Kaur, Learned Counsel, prays for 10 days time to ascertain the present address of respondent number 4 and file requisites. List the case of 2/12/2024. Requisites with correct address shall be filed within the set time.
Item 16.
delay 127 days, my lord. Respondent one has already appeared. What is your wish?
What is the delay?
delay कितना है?
Delay of only 27 days.
Yes. You're Mr. Das.
The popular delivery had not been solved.
No, we are condoning the delay, thereafter they will serve the
Well, Lordship,
writ appeal.
well, Lordship has for 159 days. And you are saying that 157.
Calculated.
Last order, I see.
159 days. Stamp reputed wrong must be the wrong calculation. All right, 159.
They have stated in the limitation of section 1 to 2.
That is why he's reading from the limitation. Okay, 159 days. So we are condoning the delay. We'll ask him to serve a copy of the writ appeal on you.
The matter related
Yes.
to reduction of the DPL. What they have taken the stand is that to retain the.
I have 2528. When will you file the certificate? Why don't you tell us from before? Why do I always have to ask you when you will file the certified copy? And in some cases, you can say that I've already filed the certified copy.
7 days and 75 days.
Mr. K.C. Corral, an additional government advocate, prays for 1 week time to file the certified copy of the impugned order. Concerning the said submission, the IA is disposed of. The certified copy shall be filed within 1 week as undertaken. IA 2529 of 2023 for 2529. This IA has been filed for condemning the delay of 159 days in filing the writ appeal. Mr. Pramod Kumar Das, learned counsel who has appeared on behalf of the respondent, submits that the objects to the application stating that the appellants have not even calculated the delay and have properly and have stated that in the petition that there is how many days delay
159. Your lordship pass out.
in the petition.
Your lordship order.
But in the petition, how many days?
They have stated 127 days.
127 days delay. Considering the reasons stated in the application and in the interest of justice, we are inclined to condone the delay in filing the writ appeal, but subject to payment of cost of ₹5,000 to the respondent within a period of 1 week. This is the case on 2/12/2024. Copy of the writ appeal, list the case on 2/12/2024. Copy of the writ appeal shall be served on Mr. Pramod Kumar Das, learned counsel for the respondent. You want to take in to pay the cost within 1 week, please note it in your file. Item 17.
Item 17.
My lord, there has been a delay of 126 days in preparing this writ appeal, my lord. My lord, please to issue notice on.
Yes, he has
question of-
appeared.
Yes, I have a. Only to delay the process. Yet I did question. This is this is regarding rehabilitation assistance appointment. 20 years have already passed. And director has directed the inspector of schools to it was now due to give him appointment. But instead they are not giving, and in the meanwhile 20 years have already passed.
When was your
Basing on the judgment of the Honorable Supreme Court, the Honorable High Court has passed, and the ordered government council also agreed to that. That means after settlement, they have come to the appeal.
settlement?
Yes, this is the ordered council does not dispute the position.
So you had settled the matter with the government council?
No,
Then?
but in the order, my lord, I am reading.
No, order you are saying you agreed, so you are saying the matter has been
They
settled?
agree.
Yes.
Yes, they agree. They agreed to the position.
Had they filed a counter affidavit?
No, sir.
Sorry,
Copy not served.
counter copy not served.
Yes, in that case, they have filed counter copy. And after the judgment of the Honorable Supreme Court, the learned counsel appealing for the state agreed to the Supreme Court judgment, and thereafter order was passed. After the agreement, they are filing appeal.
Can he agree?
Yes,
On his agreement, can order be passed against the law?
yes.
Your
So, Lord, I am
lordship,
reading the order.
Yes.
your lordship, page 46, the improved order.
I am reading the Honorable Court order. Parat 3, learned counsel.
Not para 3, we have to see from whether it is of the first state or
First date.
So please show the copy of the counter affidavit filed by them.
Yes. In the counter, they have written many things. But after judgment of the Honorable Supreme Court, they agree to the judgment of the Honorable Supreme Court.
Ito नहीं है.
After the judgment of Honorable Supreme Court, they agreed that this is the position.
All right.
After their agreement, the order was passed.
All right.
And just thereafter, they are filing appeal, which is not
Okay. कौन है डॉक्टर?
This is that case that Malayananda City, my lord, of the
So if you get position, that the case is covered by the city's case. And thereafter, they are filing.
All right.
Let me submit that. The other day,
Right, even he like 20 years already was.
Yeah, this is this is working. This one is not.
We'll hear you on merits.
They have agreed the position that the case is covered by the Malayananda city's case, which has been disposed by the Honorable Supreme Court. After the agreement, they are filing appeal. Only to delay the process. 20 years have already passed.
What is Malayalam Sati? What has been held in Malayalam Sati?
ठीक करो.
Malayananda city case that the case of the law, the rule which was prevailing then, that is applicable to the present cases arising of the.
This is what has been held in Malayalam Sati. Have you read? Have you read the decision?
Yes,
This has been held in Malayalam Sati.
yes.
Do you have a copy?
You filed a counter affidavit. It's the 6th order, not the first day order.
Yes, sir. So like
sixth order.
Where is that? Where has it been held by the Supreme Court in Malayalam Sati that the date of death should be the criteria for consideration? Applicability of rule.
I shall point out that.
I shall point out. Read Malayalam Sati twice and then come tomorrow. All right. Read it twice. And then tell us whether any law has been laid down in that case or not.
In that case.
Mr. Counsel, you read it twice and then tell us tomorrow whether in Malayalam Sati it has been held that the date of consideration, the relevant rule applicable on the date of death shall be applicable. If that has been held, then we'll see.
Other judgments also. I shall go in that extent.
So whether the order has been passed in light of some other judgments, then
Yes, I shall tomorrow I shall point out.
If your lordship permits me, the other day,
therefore we are saying that read the judgment twice
Yes, I shall.
and just examine what difficulty the Supreme Court was facing in that case. All right, then address.
Yes.
Malayalam Sati is not.
Mr. Srikant Prasad Paul and counsel for the respondent prays for an adjournment till tomorrow to address this court on the question of applicability of the decision of the Supreme Court in the case of Malayananda Sethi. List the case tomorrow as prayed for.
Item 18.
18 is, it is 148 days delay, same Malayananda City case.
Nobody has appeared.
No. AD not.
Yes. List the case tomorrow. List the case on 25/11/2024. In the meanwhile, the up-to-date postal tracking report shall be downloaded and attached to the file.
Item 19.
No, on behalf of the case of prefer next week, Mita is removed.
You're for whom?
Appellant.
What is the delay?
Case is pending since 2023. I think last time we'd given you a chance. Remove the defects. You don't have, must not be having the file. Last time nobody appeared, we granted time for removing the defects already. You are Mr. Mahapatra? You are Mr. Sahu? Mr. S.C. Sahu, learned counsel, appearing on behalf of Mr. Tapan Kumar Biswal, learned counsel for the appellant, prays for 1 week time to remove the defects pointed out by the stamp reporter. Full stop. On 4/11/2024, 2 weeks time had been granted for removal of defects. Hence, time is granted, 1 week time is granted as last chance for removal of defects. If defects are not removed within 1 week as undertaken, the writ appeal may be dismissed. List the case on 25/11/2024.
Item 20.
Here, the requisites will not be filed, so notice has not been for the sending of notice. I pay 7 days to file the requisites.
Why
I
could it be-
directed office to file the requisite. 7 days to file.
When was the order passed?
Hello?
When was the order passed? When notice was issued?
Order was passed 4/11 now.
All right. No, 4/11 asking you to, but the wrong date was fixed. It have been 16/12. Mr. K.C. Kaul, an additional government advocate, prays for 1 week time to file the requisites. Full stop. Requisites, if requisites are filed within 1 week as undertaken, notice shall be issued, fixing the returnable date within. Now, this probably connected matters are there today. That is why we may have posted it today. We issued notice on 4th, but posted on 15th. Requisites, if requisites are filed within 1 week as undertaken, notice shall be issued, making it returnable within 4 weeks. List the case on, yes,
16/12.
yes.
Item 21.
There is a delay of 144 days. Has been matter was taken up on 3rd February 2023. On 2nd February, met it in accident. That my right leg was fractured. The order was passed that the order was passed on 3rd February.
Yes.
So the writ application, you have not impleted the selected candidates. That is why it was disposed of. Yes.
So then, what can be done? You have filed writ appeal. Just tell me.
Yes, filed a writ appeal challenging the order, seeking for evaluation of our answer sheet. This is item 21. Asking for 1 mark. Now all appointment, everything must be over.
No, one post was kept vacant. That the stay order was passed by the tribunal. That much was accepted by the court after transfer to the head.
Pending since 6 years. Disposed of in 2023 and you are filing the writ, moving the writ appeal now.
It was not listed, but filing.
It is not listed.
8/28/7/23 I have filed. I have filed the writ appeal on 28.
No, that is all right. But you are challenging a recruitment of the year 2015-16.
Yes.
9 years have elapsed in the meanwhile.
Yes. But the large number of posts are there vacant. At that time, 263 posts were there. Only OPSC recommended 150 candidates.
All right, you accept notice. We call on the delay and hear it.
How much the time?
Delay is how many days? Date, have you served a copy on the OPSC? Counsel appearing on behalf of the OPSC? No, you serve a copy on the counsel who was appearing on behalf of OPSC. Mr. Suraj Mishra, learned counsel for the appellant, undertakes to serve a copy of the IA for condemnation of delay on the learned counsel who was appearing on behalf of the OPSC in WPC bracket OAC number 3012 of 2017 by tomorrow. List, sorry, by 21/11/2024. List the case on 25/11/2024. All right, it will come out next week. Please serve the copy by 21st.
Item 22.
My lord, early limitation.
Correct?
In 10 days, I will file the limitation application. Sir has recently pointed out the limitation. He filed a limitation.
Sir has pointed out means there was actually no limitation.
In fact, may not be, he was to be filed on 4/9/23.
Where is the SR?
Late generated, but
Where is the SR? There is no page marking for the SR.
subsequently after filing the certified copy. Sir has pointed out.
You actually filed it within time.
Yes.
Where is the SR page, please? That has not been done. Subsequently, it was done. You can't find.
The matter had gone to Supreme Court.
Yes, my lord.
What happened?
That Supreme Court has is a liberty to file the review application before this.
Page 22. But why are they not showing? How many times do you point out all these things? 576 days. All right. Mr. Tushar Kumar Mittal and counsel undertakes to file the undertakes to take steps for limitation within 1 week. List the case on 25/11/2024. List the case on 2/12/2024.
Item 23.
You will file it on because you're asking for 1 week.
Within 7 days.
So within 7 days gets completed on 24th.
22.
Yes, undertakes to file the take steps for limitation by 22/11/2024. List the case on 2/12/2024. Yes.
Item 23.
Okay.
36.
List the case on 25/11/2024. Registry shall download the latest tracking report and attach it to the file. Because it's the tracking says, the report says it has not yet been delivered. All right. You are Mr. Palay? Escape Palay. Yes.
Item 24.
August coming, so the other end is like this matter will be question of 10 factors.
How many days delay?
20 days delay. I am for the respondent.
We are condoning.
We are condoning it. What is your name?
Sri Sukla.
Sorry?
Sri Sukla.
G.
Sri.
Sri. SHRA.
SHRE.
SHRE. Yes. Likh diyo, Miss Sri Shukla on behalf of Mr. Agasti Kanungo. 4580/2024. This IA has been filed for condoning the delay of
Judgment dated 26th of April.
condoning the delay of 36 days in filing the writ appeal. Mr. S.C. Das, learned counsel, has appeared on behalf of the respondent. He doesn't have any serious objection to the application for condonation of delay, full stop, considering the period of delay and in the interest of justice, the delay in filing the writ appeal is condoned. The IA is accordingly allowed and disposed of. Copy of the appeal memo. Have you received?
I have received the copy, but that is not legible, sir.
Copy of legible copy of the appeal memo shall be served on Mr. S.C. Das, learned counsel, appearing on behalf of the appellant by 20. Can you serve it? Do you have the file? Can you go to the office and get the file? I mean, not today. That is, I'll grant you, accordingly, I'll grant you time. By within 1 week, list the case on 2/12/2024 for fresh admission.
Item 25.
there's a delay of 204 days in this of filing the appeal. The issue involved is whether the OCS rule till 1990 is applicable or OCS rule 2020 is applicable for for consideration of the application, for consideration of the application.
I have already entered my application.
No, it is again that rehabilitation assistance scheme.
Yes, my lord. Yeah, taking it.
So we condoning the delay, we can hear it. Fresh admission. There is the delay of, sorry, IF of condonation of delay. Oh, when did you appear? No, don't give it here.
Yes, I have 14 November.
Oh, 14.
I also filed my application.
5,000.
Nothing is there. Yes. IA for condonation of delay. This Mr. Ranjit Mahanti, learned counsel, submits that he has appeared on behalf of the sole respondent and also filed his objection. Objection, full stop. Heard Ms. Aishwarya Das, learned additional standing counsel, and Mr. Ranjit Mahanti, learned counsel for the standing counsel for the appellant, and Mr. Ranjit Mahanti, learned counsel for the respondent. Concerning the period of delay and the reasons stated in the application, we consider this to be a fit case to condone the delay in filing. In the interest of justice, we consider this to be a fit case for condoning the delay in filing the writ appeal, but subject to payment of cost of rupees 5,000 to the respondent within a period of 2 weeks. The IA is accordingly allowed and disposed of. List the case on 2/12/2024 for fresh admission. Do you have a copy of the appeal memo? Yes. Mr. Mahanti submits that he has already received a copy of the appeal memo. Yes.
Item 26.
No, we do not agree with the view taken in those decisions. And therefore, we are referring the matter to a larger bench.
Not,
We have framed questions.
yes.
We have framed 5 questions.
No.
Whether the referring to those 7 decisions which we are relying on, whether the observations made by the Supreme Court in paragraph 8 of Mohinder Singh Gill has application to test the correctness of a purely administrative order by an authority which is stayed within the meaning of Article 12 of the Constitution, cancelling a tender process before acceptance of the bid of a tenderer. Second, whether there is any requirement of giving an opportunity of hearing or prior notice before cancellation of tender notice to highest/lowest bidder, keeping in mind the settled legal position that such bidder does not acquire any vested right to have the auction confirmed in his favor on that basis alone. Third is whether the Supreme Court's decision in case of Sudhir Kumar Singh on the point of compliance of principles of natural justice is applicable when a tender process is cancelled prior to confirmation of tender/auction in favor of a bidder. Whether the division bench in case of Bansal Infra Projects Private Limited has incorrectly applied the Supreme Court's decision in case of Sudhir Kumar Singh. Fifth, whether it is permissible for the High Court exercising power of judicial review under Article 226 of the Constitution of India to direct the state or its instrumentalities to accept the bid of a lowest/highest bidder upon interfering with the order of cancellation of tender on the ground of violation of principles of natural justice or such order not being reasonable. So these are 5 questions which we have framed. Let this matter be placed before the Chief Justice for placing the matter before a full bench for authoritative pronouncement on the aforementioned legal issues.
Lordship is fixing a date,
We will fix a date. The Chief Justice will fix a date.
first week of December.
We'll see.
Not this month. I have two family functions
All right.
outside the state.
All right.
So first week of December.
First week of December. And will not, with your lordship permission, I have a suggestion. And the principles of legitimate expectations be added to your lordship's queries.
You can argue then.
Unless and until.
These are the five questions which you have framed. The question of legitimate expectation have not been addressed in those 7 decisions. So we are confining to the correctness of the law laid down in a law discussed in those 7 decisions. So legitimate expectation we will see when your case is taken upon merits after these questions are answered.
So principles of natural justice, audio alterum partem, that is there with us. Principles of natural justice.
That is it.
And the further query is that, with your lordship.
See, the first question is, all these 7 decisions are based on the observations made in Mohinder Singh Gill.
And Maneka Gandhi.
Maneka Gandhi is not there.
And other.
Whatever. Mohinder Singh Gill, whether Mohinder Singh Gill applies or not in contractual matters, particularly when decisions are taken by administrative decisions are taken by non-statutory authority. Mohinder Singh Gill refers to statutory authority in exercise of statutory power. So that is the difference. Mohinder Singh Gill, we have our doubts. Mohinder Singh Gill shall have application. Second, natural justice, it has been repeatedly held by Supreme Court in so many decisions. Then in contractual matters for cancelling tender, there is no requirement of giving any opportunity of hearing. This is what is the view which has been taken. Only after the contract is awarded and you start work, you act upon that. Then if any adverse decision is taken, of course, the principles of natural justice will apply, as has been held in case of Sudhir Kumar Singh. Right. In Sudhir Kumar Singh also, after the contract was awarded, he had started working.
Yes.
And thereafter, 1
year of the contract was left.
Exactly. So therefore, Sudhir Kumar Singh, we have our doubts. Sudhir Kumar Singh will apply. So, and then in any case, whether the High Court can direct that you award the contract in favor of L1, that is the question. Even if after reaching a conclusion that decision to cancel was illegal, whether the High Court can issue a direction that now, since the cancellation is bad, grant the work to. These are.
The paperwork will be prepared.
Yes, everything.
And the citations, do I need to give copies or I'll just give a list of the citations?
As you wish.
No, because some of the honorable bench are insisting upon giving copies, but it will be convenient because 9.
You had already given copies, I think.
No, I'll be, now that it will be, the matter will be referred to a full bench, there will be some other judgments which I have to rely upon.
Yes.
So that will be maybe 10, 15. I'll give a list of citations much beforehand. So
yes, that is what you are required.
Those journals can.
That is what you are required.
Grateful, buddy.
Item number 1.
As far as the bank's appeal is concerned,
Yes.
and is agreed by the fact that the Venerable Single Judge has directed that the respondent be awarded promotion 5 rounds, even only on the basis of seniority, even though the policy of the State Bank of India, which has a statutory goals, that says that the promotion can only be based on seniority come merit. Merit, my lords, as far as merit is concerned, that is something which was not available with the petitioner, which is also page 45 of the brief, your lordship takes.
Let us see the order first.
Yes, Madam, that's a part of the order. That's a part of the order, page 45. There is a table there, Madam.
Yes.
There are in this table, what has been extracted is from the policy. As per the promotion policy, best 4 years out of 5 years.
No, you are reading which page?
Page 45, Madam.
Page 45.
There is a table
Yes,
on the right-hand column.
yes.
Is Balar's the policy of the State Bank of India, the promotion policy of the State Bank of India, which has been extracted here under in the RTI reply. It's also here. I have a copy of that policy. Your Lordship, will share that. The Lordship has the policy. The first bullet there, my Lords, there shall be 2 channels for promotion to the grade of MMGS2 and MMGS3, a merit channel and a seniority cum merit channel. My Lord, here the writ petitioner comes under the seniority cum merit channel. Now, my Lords, thereafter, 5th bullet, 4th bullet, for promotion under seniority cum merit channel, marks would be awarded for seniority. The best 4 out of 5 years AARF, that is best out of last 4 years AARF for promotion to MMGS 3 under merit channel would be reckoned. Now, when in the impugned judgment, when the matter was taken up for consideration, the petitioner did not have more than 2 years of AARF marks.
What is ARF?
AARF is yes,
Appraisal report.
assignment appraisal report form. Every year, every officer is graded in this assignment appraisal report form. So, Malak, one needs to have 4 years of this tabulation to be considered for promotion to the next rung.
No,
As-
4 or 3.
For in respect of MMGS 3, it is 3 years. But
No.
here it was a case of
No,
4 years.
It is for MMGS 3 only.
3 only. As far as MMGS
bullet-
1 is concerned, or 2 is concerned,
No,
it is 4
bullet-
years.
Bullet point number 5
Yes, brother.
does not deal with MMGS 2. It deals with MMGS 3
That is
only.
dealt with in para 2 of that policy. There is a
Yes.
provision for total number of chances for promotion to the grades of MMGS 2 and MMGS 3 under both merit and seniority cum merit channels. Chances availed only for the promotion year 2007-8 and onwards will be counted for determining the number of chances available. Thereafter, as far as MMGS 2 from JMGS 1 to MMGS 2, one required 4 years of
No. This is only for MMGS 3.
No, madam. No, madam. The best out of 4 out of 5 years ARF / best 3 out of last 4 ARF for promotion to MMGS 3 under merit channel.
So it doesn't refer to MMGS 2.
Even assuming,
There is no question of assuming. There is no question of assumption. It says MMGS for point 5, the point 5 mentions
yes.
that if there are 5 years of ARFs, then 4, and if there are 4,
Yes.
then 3.
3. Well, let us take that 4 and 3. He did not have more than 2.
No, he is claiming promotion to what?
From JMGS 1 to MMGS 2.
Then this will not apply.
No, kindly see at the top. Promotion policy for general cadre officer for promotion to MMGS 2 and MMGS 3. So MMGS 2 is JMGS 1 to MMGS 2.
We understand. But the question is whether you can apply this bullet point 5 or not.
My lord,
This applies only in case of MMGS 3.
no, my lord, that is only for a restricted, as far as my contention to your lordship, subject to your lordship acceptance is, as far as 4 is concerned, as far as JMGS 1 to MMGS 2 is concerned, it has to be 5 years, out of which 4 years can be
Where
taken.
is that?
That, my lords, complete reading of the entire policy. would
No,
reveal that.
there is no question of conjoining.
Take the statement for the
All right.
Promotion policy for general cadre officers for promotion to MMGS 2 and MMGS 3. The Executive Committee of the Central Board in meeting on 28th December 2007 has approved a revised promotion policy for general cadre officers for promotions to MMGS 2 and MMGS 3 for implementation with effect in the current promotion year, that is 2007-8. While detailed policy guidelines are enclosed, salient features of the policy are as follows. 1. Channels for promotion to the grades of MMGS 2 and MMGS 3. That is from JMGS 1 and from MMGS 2. These are the positions from where one can seek promotion. A merit channel and a seniority cum merit channel. There is a provision for the total number of chances for promotion to the grade of MMGS 2 and MMGS 3 under both merit and seniority cum merit channel. Chances availed only for the position year 2007-8 and onwards will be counted for determining the number of chances availed. For promotion under each channel, eligible officers would have an option to opt out of the promotion process for the relevant promotion year. For promotion under seniority cum merit channel, marks would be awarded for seniority. The best 4 out of 5 years AARL would be returned.
I cannot read something which is not there in the policy.
Which point is this, Madam? There is a policy in place. The policy requires that the merit is to be evaluated. Seniority is there. Merit is to be evaluated on the basis of something. What is that something?
You decide.
It is the ARF mark.
No.
Yes, madam.
Where is that? Where is that?
The best 4 out of 5
That
years.
is for MM. Therefore, MMC, the position of MMGSC
Yes.
must be highly responsible position. And therefore, this additional provision has been met that it shall be reckoned based on 4 out of last 5 years and 3 out of 4 years.
My lord, even if your lordship's interpretation is that, my lord, even then the judgment of the learned single judge
We
is
cannot have a different view. We cannot have a different interpretation. This does not require any interpretation. The language is amply clear.
Your lordship's your lordship's interpretation that only for promotion from MMGS
Exactly.
2 to MMGS 3,
If this
this is the requirement.
If this is the policy,
Your policy.
then this is your policy, and then we cannot read something into it which is not there.
My lord, in that case, my
And
lord,
then why? All right. Then why MMGS 2 is not mentioned in point number 5?
because the bracketed portion is only for MMGS 3. The bracket would not have been there. Had it only been meant for MMGS 3, the entire cause,
Yes.
the bracket becomes redundant then. Can you, my lord, see it that way, my lord? If the bracket, why has it been bracketed?
All right.
It is
Yes.
only bracketed for the purpose of evaluating MMGS 3, that in case of MMGS 3,
Exactly.
And
3 out of 4 can be taken.
and what about
Exactly.
MMGS 2?
As far as anything else, 2, it has to be 4 out of 5.
Oh, yes.
As far as MMGS 2 to JMGS 1 to MMGS 2,
No. First tell us about MMGS 3.
MMGS 3, you either have 5 years ARF, 4 can be taken.
Yes.
Even if you do not have 5 years, you have 4 years, 3 years would be taken.
Obviously, you have stated
That is
that.
only in case of MMGS 2 to MMGS 3.
Yes. Yes.
But as far as JMGS 1 to MMGS 2 is concerned, it mandatorily has to be 4 out of 5 years.
Where is that? Must be there somewhere else. But it has to be there somewhere.
My lord, in that case, your lordship may grant me some time, I will get the entire policy, because these are only the salient features. Let me get the entire policy, perhaps the things will be clearer there. My reading of the salient features makes it very clear.
May I clarify the position?
No, let him complete.
The Mahapatra maybe can help you.
Just a minute. Milord, actually, if your lordship permit me, the promotion policy, this is combined for 2 and 3. This is seniority, then and merit. For seniority, best 4 out of 5 years ARF, best 3 out of 4 years ARF for promotion under merit channel. It has been clearly stated, if it is under merit channel, then MMGS 3 for merit, that is 3 best out of 4. But otherwise,
It has not been clearly stated. Because
that is the
That is the reason why I said that.
You are representing
The bank is
You are representing bank.
Bank. That's it.
You are, how can you have such vague policy?
No, these are only salient features. These are.
because you have the
Let me get the entire policy.
Let us have the promotion policy.
Yes, ma'am, I'll get the entire policy. I'll get the entire
You
policy.
may be correct, but there is ambiguity.
Yes, ma'am, in this, when they called out the
All right,
salient features,
all right.
maybe it is not that clear. Let me get the entire policy and place it before you.
All right.
Yes, now we should have this opportunity.
My lord, I just pray your lordship to have some, just this is the honorable, the learned counsel from the opposite party. They are just confused because they are not going to the real issue. What they have mentioned.
We will go into the real issue later.
The real issue they have said, this is the real issue concerning the disobedience of the orders of the honorable court.
All right, we will see the promotion policy first and then, all right.
Okay.
And this is the only question. Mr., as we have understood,
Yes, sir.
the only question involved is that the promotion to MMGS2 is based on seniority cum merit. Seniority cum merit or merit cum seniority?
Seniority
Two
company.
channels.
Seniority cum merit.
Merit.
So seniority cum merit. It is easy to determine the seniority, but what should be the criteria for determination of merit? That is the only question.
That is the only question.
All right.
My lord, just 2 minutes, I'll just explain, 2 minutes only.
You should explain, but we must have the promotion policy.
This is where the policy, I'm having the policy.
Mr. Pati, listen, if we hear you now, we are not able to take any decision. So we'll hear everything on the next date.
Okay.
We will hear you, that we assure you.
Just a short date.
Yes, yes.
All right. How short?
Are you please, madam?
25th.
When?
25th.
Let it be a week after so that I can get the
As
policy.
jointly requested on behalf of the party. These matters on 25th.
25/11.
Retaining its position.
Okay.
Item number 2.
May I please your lordship.
Matter, my lord. Where I have challenged the Pensionary seats has been forwarded to the general candidate, my lord. I have challenged that and the.
Now, what can be done? We have indicated on the last date also. Have you examined?
Yes, I have examined and I have gone through those judgments and found that their lawsuits are held where there is illegality and arbitrary has been done. The lawsuit has got ample power.
No.
Yes,
We have not. Let us.
We may be able to say whether it is illegal or, but we can't help you because the date has gone.
No,
That
date
the
is
problem.
there, madam. Date is there.
How is it then?
Yes, madam. The date of counseling is, the special round of counseling is, state rounds counseling is fixed to 25th of November to 29th of November.
Okay.
That's what, the date is there.
Here, just now you make copy for DMT, but JE is the main party here. Orissa, JE my lord, who is conducting the counseling.
Have you served a copy?
Yes, today just now I am giving sorry for DMT, I will get.
Today? You served him a copy today?
Yes, ma'am.
Yes, madam.
So let him go through.
The state counseling is fixed up to 25th and up to 29th, and the last date of joining is 30th.
Serve a copy on Mr. Pallit.
Yes, I have already solved.
Where is the date scheduled?
Date schedule.
Date schedule.
Yes, please give.
That's it.
Did you inform Mr. Pallit that the case is listed today or you served him a copy today?
Mr. Pandit.
Okay, anybody for the BPUT, have you served copy?
No, ma'am. I am not.
And you said yes when I asked.
In course of the day, I will serve. In course of the day.
It's for your own benefit that you should have served it earlier. Special roundup. What is this document? Who has issued this document?
That is generated in the net itself, my lord.
All right.
For counseling.
All right.
No, whether it is there on record or not.
Yes. Recording is not there.
Recorded can't be because
Yesterday they
it
have.
must have been published for the leftovers. So,
Yesterday they put it in the. Their website.
you can say
Their website, fine. I have downloaded it.
All right. Tomorrow. Yes.
In the meanwhile, you will serve a copy. And the council
Yeah,
approval
serve.
on behalf of the.
Yes, sir.
Yes, I have thought
So
so.
are we just to
Oh, you're not listening.
Are we just not solved? Would you?
In course of the
Without
day.
hearing the question, you're saying yes. So ultimately, order will not be passed. He is not served.
Definitely. In course of the day, I will solve it.
With this matter tomorrow. Get a copy of the writ petition we served on learned counsel who generally represents the JEE, what do you call? Joint?
Joint interest.
OJE. Joint entrance examination. OJE.
Examination, something. Examination cannot be done.
Chairman OJE,
Yes, ma'am.
opposite party number 4. Chairman,
Sir,
Chairman, Orissa Joint Entrance Examination 2024.
going to
Opposite party number 4.
opposite party number 4.
In course of the day, not
Course-
tomorrow.
No,
Yes.
in course of the day.
Item number 3.
May I please, Lordship, for my lord, direction, I will start the copy to my respected senior, appearing for the DMAT. My lord, the limited grievance of the petitioner is that after passing the MBBS examination, my lord.
Mr. Mahanti, there's a mistake in his that number.
Yes, ma'am. That I
Yes.
have pointed out.
Yes,
That I have pointed out. I have got the instruction.
you have pointed out.
No, that is,
Oh, you have noted.
Yes.
Yes.
I have noted it. So he has to make PG, permanent PG is the necessary party because that is the body who is goes for this admission and comes on. He has not made
PG, because it is PG admission, so.
permanent PG.
Convener, PG,
Counseling Committee 2024.
what is it? Kagaz
President,
You should not suffer for mistake of the council or whatever.
This has been published in DMAT website, my lords.
So it is your mistake, your mistake?
No, my lord. It is that I will show you my lord.
Yes.
The
And who appears for the PG council usually?
council I appear.
You'll appear.
It's not our letter. The problem is the admit card he has given.
Yes.
That is a roll number. The scorecard he has given. That is another roll number. And the notice which was given by the NET, National Board of Examination and MO, Ministry of Health Science, my lord. They have given the list where we have not given that list. In that list also number is something different.
No, roll number is different, the other number is different. Application ID.
Roll number is different.
The roll number may be different. Application ID here has been changed.
Yes, my lord.
So that is not his fault.
No, then this is only National Board of Examination. They can say what is this. They have not given the board. The result is they have sent to us in the website. That is also there is a wrong. That's why we have not. He has not applied to us for registration also. He has not applied
Not
to PG
understanding what
council.
he's saying.
Who has committed the mistake according to you? Now you are counsel for the petitioner.
My lord, it might be National Board of Examination which has published and given this.
So whether he is at fault or not, he is at fault or not?
No,
Whether he is at fault.
No, how can we say whether he is in fault or not? Because
You cannot say whether
we
he is at
cannot
fault
say.
or not.
No.
How
Now,
can he
if
be
you
at
are
fault?
appearing for him, then
How can he be at fault?
No, whose fault is that is still pointed out because we are not in a position to accommodate him. We did apply for our restriction. The notice which was given in this thing, that is by the MOH, my lord. There is also the different name is there, room number is different. Percentile is 18 some odd, but his score sheet is 97 point percentile.
so who will say?
That is any National Board of Examination that will have a party here.
National Board of Examination is a party.
My lord.
Have you served a copy on?
Like Union of India, yes, my lord, I've served a copy to the office of the Deputy Solicitor General. my lord. Last copy on
Office of the?
Is there any order?
ESIG, my lord.
Yes, I see.
On 14th also, my respected senior Mr. Pari appeared with the.
Yes. He appeared, probably gave a appearance memo also. Yes, Mr. Padi, what are your instructions?
My lord, I have not received any instruction, my lord, only 1 week's time I have given.
No, 1 week will be very late.
Who is the competent authority?
My lord, only 2-3 days I have no file, my lord.
OP number 2, my lord.
OP number 2, who is OP number 2?
Ignore your appearance on the last day.
President, National Board of Examinations in Medical Sciences.
Last order है नहीं था, order पास है क्या चेक? ये website रे किसी order है क्या? Appearance memo दे देते हैं तो not.
It is the petitioner's grievance that he had appeared for. He had appeared in National Eligibility cum Entrance Test, bracketed NEET PG 2024, conducted by the National Board of Examinations in Medical Sciences with roll number 246611788689 and application ID PG 2400112. Whether the last date is over or last date for admission?
No, my lord. Now the registration has been started.
It is his case that with the aforesaid roll number and application ID, comma, in the scorecard published by the NBE, the petitioner's rank was 632726. Is it correct?
My lord,
6326. 26.
the application ID was PG 2400112. That is the original number.
Page.
No, my lord.
My lord, annexure 4 case.
Thereafter, the state candidates list for state registration of PG Medical Council was published in the DMET website, on the DMET website, which reflected a wrong application ID of the petitioner, that is
my lord. PG 2409518.
440, repeat it.
PG 240-95180.
instead of PG 24201112. Stop. In the said state candidates list, comma, the petitioner's rank has been altered to
175968.
157968.
175968.
175968 in place of 6326. So stop. This is the background in which the petitioner has filed the present writ application seeking direction to the opposite parties to correct the application ID in accordance with the petitioner's admit card and scorecard issued by the NBE, comma, bracketed neat -PG, and assign appropriate rank of the petitioner in the state candidates list. So stop. Considering the urgency of the matter it relates to admission to PG medical course, comma, which process is time bound, comma, list this matter on Wednesday. So in the meanwhile, learned DG, DG, Deputy Solicitor General of India, shall seek instructions from NBE, NEET PG 24, as regards the discrepancies as noted above, comma, as has been pointed out by the petitioner in the writ petition. So stop. We expect some responsible officer involved, associated in conduct of National Board, what is that? National
Board of Examinations in Medical Sciences.
To join the proceedings at 10:30 on
2011.
20th. Yes. उसमें लिखो, on the oral prayer made on behalf of the petitioner, the convener, comma, PG's bracketed medical sciences,
Medical Counseling.
Meddling Counseling Committee 2024 at VSS Medical College. What is that? Burla,
Sambalpur.
comma, Sambalpur is permitted to be added as opposite party number 5.
You give the consolidated cause title in course of the day.
Consolidated cause title
When insertion.
be filed in course of the day. So stop. next step. We also expect Mr. Mohanty to seek instructions from the newly added opposite party number 5 in relation to the controversy, to the dispute as raised in the writ petition.
And Mr. Padi, copy has been served on the learned DSG because he had appeared on the last date, that is Friday. All right. So kindly obtain instructions. Yes.
Grateful, my lord.
Press admission item number 4.
Restoration.
Okay.
Because by then, I do not appear in the cause list in the case was called up, so I could not know. But I was not the original counsel, the previous counsel was conducting the case, so that is why I could not.
If the previous counsel was appearing, why should your name be indicated in the cause list?
In the past date, well, it was, my name was there, page number 6, 25.
Where is the order? Where is the order of dismissal?
Not there. No, sir.
Yes.
Mr. Mahdi,
My lord.
what number have you given? CMPL 2 of 2021.
April 154, present 154, 2021.
No, this cause list we have given.
Cause list, my lord, earlier CMPL was there, 2 by
So
21.
this is for restoration of the CMPL.
It was restored. Writ was restored. So when the writ was called on for hearing, final disposal, page number 7, WBC against WBC 8367 by 80.
So once earlier it had been dismissed, thereafter it has been restored. After it was restored, it was again dismissed.
Again dismissed against the WBC. So fairly, my name was not there.
Given the name? What is this? Annexure 1. Annexure 1 is the copy of the cause list.
Cause list, page
Yes.
6 and 7.
Yes.
6, my name is there in the, against the CMPL.
Yes.
But in 7, page number 7.
No, forget everything. Come to the order sheet of WPC 8367 of 2018. This is not the way the case is conducted.
Well, that is why I have enclosed the.
You have liberty, file separate petition by CMPL.
Presently, I say, in the meantime, the revision, when during pendency of, because I have come against the order of the Central Tribunal. So, in the meantime, the Grammar Acceptable Conduct and Engagement Rules 2020 has come into force. So, during pendency of the writ petition, my revision was dismissed on the ground of limitation. So, I pray liberty will be granted. I will avail the remedy.
You withdraw.
Yes, 2020 rule.
When counsel for the petitioner, after some argument, seeks permission to withdraw this application with the liberty to pursue
Divisional authority.
To pursue his case before the revisional authority. So stop. This application is accordingly dismissed as withdrawn with the liberty as sought.
Right.
You are saying the revisional authority has dismissed your revision. Then what will you pursue before the revisional authority?
No, because time bar, having been time bar. So I once
Revisional authority, if permissible in law. Yes.
And your name is not indicated because you filed the wakalatnama in the CMPL, not in the writ petition.
Item 5, my
Item 5.
Respondent, he is trying to file counter.
That's petition.
Hmm?
Going to going to restore and dismiss. You wanted to want to form the title objection. This one. Item 5. How many days delay?
Delay already last date of conduct.
Then we want to file objection to what?
Contrary to us to writ appeal.
Writ appeal counter affidavit has to be filed.
Right, some points they have taken in the writ appeal, so we want to object that by filing.
Orally.
No, some points have been taken in the writ appeal which were not taken.
Not
Clear.
taken in the counter affidavit by the state.
We ignore that.
So, we need the time, my lord, detailed preparation. 3 days back, we have received the writ appeal copy.
All right. Current counsel appearing on behalf of the respondent seeks adjournment to on the grounds that the respondent has received notice recently, nearly 3 days back. To stop. As requested, list this matter 2 weeks. So who wants to- Yes,
Item number 6.
yes, you are for,
Here I am for the applicant.
you are for the applicant.
If this is that case, or should I kindly remember this for 3 posts of peon in a school. First post is office peon, second is science attendant, third is night watchman cum sweeper. From out of those 3, the senior-most member is to get a promotion to the post of Daftari. The resultant vacancy will be filled up by another man who will be designated the third post of peon. Here in this case, before the honorable single judge, 3 grounds were taken. First of all, the respondent, before attaining the age of 18 years, was appointed. First. Second is, there is no evidence to show that the management took approval of the authority for giving promotion of the senior-most person from among the 3. And there is also no evidence that the resultant vacancy has been decided by the management to be filled up by the other man. And thirdly, the direction is to give him salary from the initial date. But on query, we came to know that from August to 1998, he is not coming to the school. He is not coming to the school. From August 1998, he is not performing his duties. These are the 3 grounds we have taken.
Well, kindly see page 28 that what is on a new ground, it is not actually a new ground, that the inspector of school approved the appointment of the respondent in the year 96 by virtue of this honorable court's order. In other words, my lord, they are seeking of the review of the order passed in 96.
You were appointed against 4th post.
My lord, that is when the 100, there is a more than 100 student in a high school, 4th post of peon is admissible, my lord. That is a 1981.
No, where is the direction of this court?
My lord, that is page 28, my approval. My appointment is against.
Where is the direction of this court because of which you were appointed according to you? This is what you are saying.
Well,
This is what you are saying.
Yes.
There is an order of the High Court.
Kindly see. That order they have not annexed, my lord. In terms of order.
You have to see that.
23/12/95 of the Honorable High Court of Orissa.
No, where is that?
JC number.
Where is that High Court's order?
That is there.
That is very important.
Yes, my lord.
Because you are saying that you were not appointed because of something else, but because of an order passed by this court.
This court, my lord.
So where is that order?
That is their opinion, they have to be.
And
No, your writ petition, you have referred to it, but not given the order.
It is, I am appearing for respondent. It is, my lord, that has been taken note by the honorable single judge in the judgment, my lord. And they are seeking file this writ appeal on basis of new document, which is not there before the honorable single judge. That is one part, my lord. I am not against that, let it be, my lord. Because this approval of my appointment is by the virtue of the order of this honorable court, and they have approved it. And they are now seeking review of it. It is not something new, my lord. I am 16 years old. My lord, Constitution Article 24 says below 14 years cannot be employed. But 14 to 18, the adolescence period, they can work maximum 6 hours, but not in a hazardous condition. So this is not any, my initial appointment is neither illegal nor irregular, nor my lord, there is any fraud. If in case of fraud, they can reopen it. But this is not a case of fraud or forgery. I am fighting it from 96, my lord. And now they are saying, I am not coming to the school, and this is all by the duress of the DO has written to them in the new document was there filed, my lord. My commission before the lordship is it is that my appointment on basis of that order, and they have filed a counter in the case, my lord, OJC number 1138 of 99, that is page 30. And the counter, the detailed counters they have annexed, my lord, but they have nowhere stated that my appointment is against, because I was 16 years age, that why my appointment is illegal.
But that can be seen at any stage.
But it is not an illegal appointment, my lord. 16 years, 14 to 18, my lord, they can work. My lord, Juvenile Justice Act is amended in 2000. And before 2016 years, boy is a full adult. So they can work anywhere. 18 is in 2000. My appointment is in 96.
91.
91, approved in 96.
96, you were more than 16, I think.
More than 16 years. So, may I pray, my lord, in this case, let it be, my lord, lordship may, because I am fighting for last 3 decades.
No,
Your lordship may modify the order by stating that I will only entitled for 3 preceding years, whatever the benefit, and all other periods will be counted towards my service benefit, consequential service benefit. Because it's a pure, my lord, absolute poverty, the child never comes, my lord. And he is a person being 16 years old, forced to work in that school out of absolute poverty, my lord. And the child labor is the result of absolute poverty of the social strata, my lord. So it is not a case that I am below 14 years. I am 16 years of age, and the government approved it. Government never raised question while they were approving the post. They could have examined that at that point of time. I am not saying that whether.
So was there any minimum age prescribed?
No, madam. That is always 18 years, because when government has taken over the school, that is 18 years. Government has taken over the school. Now, because they are paying it, they are raising it now. But when they have approved it, they have never raised that you are 16 years. 16 years of age is absolutely right.
That. You were appointed when?
My lord, that is my appointment with 91, my lord, after attaining age of 16.
So was there any, all right. So you are referring to constitutional provisions. We want to know whether there was any date, minimum and maximum prescribed for appointment by circular or by rule or whatever for appointment to the post of the study.
Hello. That is not there in the private school. This is a totally privately managed school, my lord. So,
No, just hold on.
With 16 years, had you raised any counter filed in the writ petition? No.
My lord, as a matter of fact, when the school is opened, it is by a private endeavor. During that period, in many schools.
If you intend to take any new point, then you could have filed a review application.
My lord, on that question, your lordship may kindly allow me to submit a lecture 4 only at page 65. It was only after receipt of the direction to give him salary from a back date. Naturally, you will have to inquire.
So therefore, you after the inquiry, you found some new facts which were not brought to the notice during the writ proceedings. Then you could have sought a review.
leaving that point aside, if we don't harp on that point, then also Rajendra Kumar Das judgment, which my understanding is taking note of, taking help of, that is also not helping her. That is available at page 52 of the impugned order. The among the within the judgment is there 5.6. Should I please?
We have to test the correctness of the decision based on the materials which were there before the learned single judge. So we cannot decide on the basis of certain facts which you are bringing to our notice now. How can we say?
Possibly I couldn't express myself properly. I was saying that even leaving aside that point.
All right, you were leaving aside that point. Then you can leave it that aside.
Then also
consider
the judgment she has relied on, that is Rajendra Kumar Das, which has been taken note of by this honorable single judge, that is available at page 52. That also doesn't help the petitioner. There the honorable court has clearly mentioned it. The issue was carried before the Honorable Supreme Court by the state of Orissa. State Honorable Court in the case of Rajendra Kumar Das Supra, repelling stance according to state government to the post of Daftari is a promotional post, and therefore the concept of fortune as sought to be conversed by the writ petitioner is without any legal foundation, expressed the view holding that these are the view of the Honorable Supreme Court. It is to be noted that post of Daftari carries higher scale of pay and is a promotional post for.
So we may consider her submission that the petitioner will not claim anything. The arrears of salary from 1998, but
we
will see.
Yes.
Just correct.
That will fail.
What are the relevant dates, madam?
The impugned judgment was that is 27/1/2023.
27/1.
27 or 20th?
27.
And your date
January.
chart is wrong.
Date of judgment. गलत है फिर।
Okay, 27/1/2023.
In 1291 he was appointed.
11/1/96 was approved with effect from date of joining.
Yes.
The present matter has a checkered history. The respondent was appointed as fourth peon by the managing committee of Nandini Vidyaniketan.
My lips.
Of Nandini Vidyaniketan, Sidho Katak since 1991. In 1991. He had joined, he or he?
He might.
He had joined the post on 17/12/1991. The post against which the petitioner's engagement was approved by the engagement against the post of 4th PN was approved by the Inspector of Schools, Cuttack. Stop. As the respondent was not being paid salary, he had filed OJC number 1038 of 1999, filed writ petition registered as OJC number.
You have not stated your file this earlier, there's some question to which.
What is his name? Petition, what is the respondent's name?
Mahadev Behera. Mahadev Behera.
Approved by Inspector of Schools, Qatar, in the light of certain order passed by this court in OJC number of this court dated 23/12/1995 in OJC number 8505 of 1994. Okay.
This was not paid salary. He had filed on June 1999.
99 for release of salary. Counter affidavit was filed. In that case, the said school was subsequently taken over by the government. Whereafter, OJC number 111038 of 1999 stood transferred to the State Administrative Tribunal, Odisha. Because of a new case was registered, the case was renumbered as TA number 668 of 2015.
WBC bracket TSC.
नहीं उसका subsequent पहले TA पहले no before trap.
अच्छा, okay, there again here.
So this is how checkered.
Yes.
पहले यहाँ फिर वहाँ 68 bracketed C of 2015. Stop. The tribunal stood abolished, whereafter the said TA number 68 bracketed C of 2015 stood transferred to this court and renumbered as WPC bracketed TAC 68 of 2015, comma, in 2019. First off, the said WPC TAC 68 of 2015 has been disposed of by a learned single judge of this court by order dated 27/1/2023, by judgment and order dated 27/1/2023, which is under challenge in the present intra-court appeal. So stop. The next is submissions which have been advanced on behalf of the state of Odisha in the present intra-court appeal are that there was no fourth post of PN sanctioned, and therefore the respondent would not have been appointed against the said post. Full stop. Secondly, the respondent's age even on the date of approval by the inspector of schools Cuttack on 11/1/1996 was less than 18 years. Full stop. It has hardly been argued by an additional government advocate that the respondent is not working in the school, in fact, since 1998.
August.
August 1998.
Full stop. Basing on the said submissions, it is contended that the direction issued by the learned single judge to pay entire arrears of salary right from since date of engagement till date is unsustainable. So stop. The learned single judge, according to him, ought to have considered the legal issue that in the absence of fourth post of PN, the respondent could not have been engaged against a non-existent post. Stop. Next, learned counsel appearing on behalf of the respondent has submitted, relying on the order dated 11/1/1996 passed by the inspector of schools Cuttack that the approval of the petitioner's appointment cannot be questioned by the state. Full stop. She has submitted that the point that the respondent was under 18 years as even on the date of approval of his engagement against fourth post of PN by the inspector of schools was not taken by the state in the writ proceeding. Stop. C contains that a point not taken by the appellant in the writ proceeding cannot be taken in the present intra-court appeal. Full stop. Next, taking a line of list resistance. Learned counsel for the respondent has submitted that the order of the learned single judge on the point of payment of arrears of salary may be modified to the extent that the respondent shall be entitled to payment of salary for the period during which he had actually worked. That will stop. Next, considering the facts and circumstances, we dispose of some circumstances and the submissions advanced on behalf of the parties as noted above, comma, without going into the Mr. AGA has submitted that the decision rendered in case of Rajendra Kumar Das, reported in decision of this court rendered in Rajendra Kumar Das reported in so and so has been wrongly applied by the learned single judge in the present set of facts and circumstances. This is your submission. Last calendar. As noted above, we deem it fit and proper to dispose of the present appeal by modifying the impugned order passed by the learned single judge with a direction to who will pay.
Inspector.
Principal.
Inspector, that is now district education officer.
To the district education officer to pay to the petitioner the arrears of salary for the period during which he had actually worked. So stop. Worked against the post of peer. So stop. The petitioner shall, can you produce some evidence that you were working?
Yes, my lord, that's, you have paid me salary for January 96 and February 96. In March,
2 months you have paid, but later, how can you show that?
taken any disciplinary action by after the payment is ordered by this or
No, that is not the question. The question is whether you were. See, you cannot get salary if you had not worked.
That's why I am admitted because
Therefore, what direction should, if you can show?
The consequential service benefit and by
No.
2003 and 4.
Just a minute.
You'll also may delete that my submission to.
That
You'll also finding direction will be enough. It is.
That is then in that case we will have to hold that.
It's not my submission. You'll also may say that, my lord, I am submitting, but that's even to reflect. So to end the litigation, my lord, I say, my lord, to end the litigation, that only consequential service benefit may be given or an arrear may be, my lord, modified only to last 3 preceding years.
Let her obtain instruction from the petitioner if she wants.
No, you can obtain instruction that this is the order which we intend to pass. Otherwise, we will have to go into all legal issues.
And
You can obtain, you can tell your client that this is the court's view, that your age, when he was,
I've already convinced him that you have to leave something to end the litigation because they can go up to Supreme Court. You can't fight.
So
That's why he is lagging my lord. But your lordship may say all other consequential.
that we will say,
Yes, my lord.
don't
That-
worry, don't worry,
That's all, my
that
lord.
we will
That
say.
may-
So
that-
for areas of.
That will suffice, my lord.
And the district education officer to determine the period during which the respondent had actually worked in the school and the salary which was payable to him. The salary which the respondent would have been entitled to receive accordingly within a period of 2 months from today. So stop. After computation of the amount of arrears of salary, comma, the same shall be paid to the respondent within 1 month thereafter with interest at the rate of 9%. So stop. We are not inclined to interfere with the impugned order any further, but we observe that first of all, we observe that the respondent shall be entitled to all consequential benefits teaching him to be in service from the date of approval of his appointment by
Inspector.
Inspector of Schools, Cuttack, while order/letter dated 11/1/1996. Consequential. Comma, notionally. For the purpose of determination of the respondent's seniority, respondent's service and post-retirement benefits. So,
Deeply obliged, my lord.
9% interest index event of value.
no, 9% interest and single judge has awarded.
Yes, my lord.
So if you find that some arrear is payable, then you pay with 9%. If according to you, no arrear is payable, 9% of 0 you can pay.
Item number 7.
This is a case of dismissal of the professor of medicine of Fakiraman College. And
Professor of medicine has been dismissed.
my lord,
A professor of medicine has been dismissed.
the ground is that in 3 occasions time was given to attend the inquiry. He did not attend. On plea of his illness was given no medical certificate. On last date of inquiry is fixed to 2/12/20, my lord. He also did not appear and file a petition adjournment. The knowledge single judge has taken view, since it was the peak period of COVID, he should have given adjournment on that. That is the only point involved.
So, the learned single judge must have directed for de novo inquiry.
Yes, sir. You will also have to decide, this is the only point.
Immediate matter to back to the disciplinary authority to comment the inquiry from that.
Serious of allegation is
Serious of?
20 to 30 days in a month he does not attend the college. Merely signs the attendance list or goes.
The dismissal.
No, expert inquiry. So therefore, the order single judge direct.
License was given or not? Page 94, Lawrence single judge observed and Kara 6.1.
Which is the item number? 7.
You had been asked to conclude the inquiry within 6 months. Had you done
6
it, it would have been over.
Page number.
Order was passed on 8/9/2023 by the inquiry would have been over.
More than a year had passed.
The state of Odisha has preferred this appeal against an order dated 8/9/2023 passed by a learned single judge of this court in WPC number 3577 of 2022, whereby the order of dismissal passed against the respondent dated 29/11/2021 has been set aside. Full stop. Set aside. Full stop. After quashing the order of dismissal, learned single judge has limited the fact to the inquiry officer from the stage of inquiry with a direction to him to issue fresh notice to the petitioner for participating in the inquiry. Full stop. Learned single judge required the disciplinary proceeding. And the impugn order required the disciplinary proceeding conclude within period of 6 months from the date of the order. So stop. Assailing the impugned order, learned AGA appearing on behalf of the state has submitted that the proceeding was initiated against him for on the charge of serious misconduct in the nature of unauthorized absence from government duty, disobedience of the orders of higher authority, negligence in government duty. So stop. In the departmental inquiry, comma, despite notices issued, comma, the respondent did not participate, though a written statement of defense was filed.
May I submit one line once? All the judges have not participated, but all the judges have filed application for admission.
So he has submitted that despite various notices issued by the inquiry officer, comma, since the respondent did not participate, comma, the inquiry officer, comma, based on ex parte inquiry, comma, held the respondent guilty of the charges. Stop. The disciplinary authority, agreeing with the finding of the inquiry officer, rightly found the charge of misconduct against the respondent proved and passed the order of dismissal. So he submits that there was no procedural irregularity in conducting the departmental inquiry, and the order of punishment cannot be said to be disproportionate to the charge of misconduct. Stop. Next. Then counsel appearing on behalf of the respondent, on the other hand, defending the impugned order passed by the learned single judge, has submitted that it was because of the COVID-19 situations / restrictions that it was difficult for him to participate in the departmental inquiry. So that is the reason why the petitioner, respondent, had been continuously seeking adjournment in the departmental inquiry on each and every day fixed for that. Every day, on 4 days. On all the 4 dates fixed by the inquiry officer. So he has argued that the learned single judge has remitted the matter back to the inquiry officer for conducting the inquiry afresh, disciplinary inquiry afresh. Stop. No serious prejudice is caused to the state because of the impugned order, and therefore the impugned order, as they have been given the liberty to proceed in the departmental inquiry in accordance with law. Stop. Next. After having perused the impugned order passed by the learned single judge and considered rival submissions advanced on behalf of the parties as noted above, in the background of the materials available on records, we are of the view that the impugned order does not require any interference. So stop. The departmental inquiry against the respondent was held ex parte. Stop. Admittedly, the respondent had written to the inquiry officer for adjournments on the date fixed for the inquiry. So stop. COVID-19 situation was 19 situation, in our opinion, was a valid reason for the respondent to seek adjournment in the departmental inquiry. Stop. Considering the nature of order which has been passed by the learned single judge, we are not inclined to interfere with the same. We do not find any merit in this appeal, which is accordingly dismissed. So stop. The impugned order, however, is modified to the extent that the departmental inquiry, that the inquiry has to be concluded within 6 months from today. Yes.
Item number 8.
Notice regarding regularization of a co-comma attendant. He was initially engaged in 2007 and in 2022, his application for regularization was rejected. He had came before this was before single judge. Single judge held that view of the case decided the Umadevi case and other cases decided by our own High Court case of data India data. Since he has already completed more than 15 years of service, he has to be regularized. So our only point here is when he was not appointed against sanction board, that is why we have filed this article. There is no finding that he was appointed as before. That is the only point.
Where is the order?
Order time.
Already has annexed page 27. From paragraph 4 onward reading, Lord and Council petition contended that petitioner to initially engage as a co-com attendant on contractual basis by order dated 31/12/27 under Annex 2. Pursuant to such engagement, the petitioner is allowed to continue on contractual basis without any break in service. It is contended that in spite of such long continuance on contractual basis, but the service of petitioner not regularized, we approach this Honorable Court WC 625/22. This court, while disposing the said writ petition, directed opposite to consider the claim of the petitioner for his regularization. It is contended that even though the petitioner at no point of time was engaged on daily wage basis, which is apparent on the face of order of the engagement issued on 31/12/27 under Annex 2, that opposite to without proper appreciation of such order of engagement, or by taking a plea that the petitioner was engaged on daily wage basis, has rejected his claim by the impugned order dated 27.
Yes, we will decide it. So whether you were appointed
I have been appointed on a regular basis.
on regular basis.
On a sanction post.
Just a minute, where is that?
Yes. I may kindly draw your attention to the original writ application 20880.
Just a minute.
The annex 1 of the writ petition.
Eight items.
Yes.
WA has arrived. In that
Just a minute.
annex 1 case.
Just a minute. Which annexure?
Annex 1. Of the original writ application 2080/23.
Got it.
Miller. The government of
No, no.
Orissa and SEBC
Annexure 1.
Annexure 1. Page number 41.
No, this is WPC 6 to 25.
2088-23.
WPC 625, what is this? Sorry.
808.
2088.
41.
2088.
Sanction post.
Huh?
I will permit to read that.
That repetition,
The-
cost title, you're getting. Cost title will be less.
No,
You have-
no, it is one. Annexure 1. Annexure 1 is copy of the writ petition.
In that copy of the writ petition, the.
Annexure 1, Mr. Counsel, Annexure 1 of WPC 2088.
Yes, sir.
That will be order.
23. In that, previously there was another writ petition.
Yes.
So-
Therefore, Annexure 1 is your writ petition.
Yes.
Alright.
In that writ petition, at page number 41,
Yes. Okay.
the government of Orissa and SEBC Development Department
Just-
created certain posts.
Just a minute. Annexure? Internal annexure?
Internal annexure 1, page 41.
That is a letter from Government of Orissa to Accountant General for sanction matter.
Yes, that
And
is
that
sanction
case,
post.
4 posts, 32 posts of peons were sanctioned. So
Yes,
for this,
I am coming to that. I'll explain the question. The government in SEBC Development Department in respect of SEBC schools created certain posts by the order 12th March 2007. And in that sanction post, there was,
No, you are reading what? Page 41.
yes,
What is page 41?
41.
Yes.
In that order, 20 posts of peons, class 4, at contractual rate of 1,500 per month was created. And the next page,
20
page
posts
number
of?
42,
20 posts of?
20 posts of 29 posts of peons in class 4.
peons class 4.
Class 4. At the rate of 1,500 per month was sanctioned.
Who one attendant was not there.
Miller, I'll come to that one. The next page. In the next page, there is a break copy. Page number 42.
Yes.
There is a break copy. Serial number 3, listed Korapur.
Yes.
And Hortaput GHS. That is the name of the high school. That's that name of the school. Hortaput High School. Where one post of peon was sanctioned.
Yes.
The next page, 43, page number 43. My appointment order, engagement order.
What is the date? What is the date of sanction?
Date of sanction was 12th March 2007.
12th March 2007.
In my engagement order, it has been clearly stated that my name is there in the engagement of Venkat Prasad Puraraj, son of Amuka, District Koraput is hereby. Girls High School, it has been mentioned also. Hereby appointed who-come attendant on contractual basis in government SSB Girls High School, Hortaput, in the district of Koraput. The name of the school has also been mentioned in my engagement order.
Yes.
That was the post created for peons.
Yes.
But somehow, in the appointment engagement order, it has been recorded as who-come attendant. But they have quoted the post created in pursuance letter number 10636 of SSD dated 12/3/2020. Yes, I am coming to that. my rejoinder. Here it is specifically stated that I have been appointed against the post created by order, by number 10636, SSD 1/12/6/2007. That was there in the sanction order. My rejoinder, my candidate. In my rejoinder, at page number 2. Page number
Just,
2.
Mr. Mahapatra, your engagement order is annexed 2,
My engagement order is annexed.
page 43.
Page 43. Then in that case, I have filed a rejoinder.
No,
In
rejoinder, but
in-
he is hereby engaged as cook cum attendant on contractual basis. Post pursuant created pursuant to so and so, so and so. Actually, that post has not been created by the said letter.
They say so. They say so that the post of cook and coordinate has not been created. The post of peon has been created. It is a mistake on their part. That's why I may kindly draw your kind attention to, I have obtained a copy of RTI application that is available at page number 12 of rejoinder, at page number 12.
Whether the post was advertised,
Yes,
whether the post was advertised.
the post was advertised as a peon. Only the mistake they have intentionally created that instead of writing the peon, they have added that coupon attendant. That they have created, and in the RTA application, they have also.
Mr. Counsel, we will not decide cases on the basis of information which you receive under RTI. All right. RTI is a different procedure altogether.
Yes.
The information which is given by under the right to information shall not determine our adjudicatory proceeding. So tell us whether there was any advertisement or not.
Yes, there
Where
is
is that?
advertisement. My submission is that
Where is that advertisement?
this was the advertisement in which the post was created by government.
Creation of post is an advertisement.
Miller, they have lost the file altogether.
Lost the file.
They have lost.
All right, very good. So did you participate in any selection process?
Yes,
Selection.
yes.
What type of selection?
Miller, I'm continuing one point. In the WA, they have given the rule that is at page 33 of the writ application. In that resolution, they say any persons regulation appointment of above category of point number 2 I'm reading, contractual employees shall be made on the date of completion 6 years from the service on or from the date of publication of resolution, which is the letter, the order in which is the names of the affairs and the graduations. The period of
Mr.
6 years.
Counsel,
But in that
seems like
resolution,
we have not been able to convey what we wanted to convey.
I want to convey that any post under Group C or Group D, cook or attendant post is a Group D post. If I would have been recorded as a PO, I could not have tested all those.
Very difficult. We are again putting the same question. Whether there was any selection procedure adopted.
Yes.
Whether the post was advertised or not.
It was advertised.
Where is that advertisement? Then you don't have advertisement, then Uma Devi is not for ever.
I say I don't cover under Uma Devi. I say on the government order, it has been stated that all persons who have engaged in Group C or Group D post and completed 6 years contractual service, where the post has been created, they are liable to be, their service is liable to be.
Where is that? Let us see.
30, page number 33.
Let us see.
Writ application, page number 33.
Which writ petition?
Writ appeal.
Writ appeal.
Writ appeal.
Yes.
Writ appeal, page number 33.
Yes.
Regulation appointment of existing contractual Group C and Group D employees who are not holding any post in contravention of any statutory recruitment rules made under the provision of 309 of the Constitution of India or any executive instruction in absence of such rule. This is the heading. This is applicable for all Group C and Group D employees. I am a Group D employee, even if my
This will not apply. You were not. Your entry was backdoor.
No, my lord. By sanction of post, in my engagement order, the sanction of post has been recorded.
What is the meaning of backdoor?
No, backdoor means there is no advertisement, there is no sanction post, there is
No, sanction post, forget sanction post. Maybe sanction post, but the backdoor entry can be to a sanction post.
maybe.
So your backdoor entry was backdoor.
But my lord.
Okay,
I have-
all right. You are saying that there was an advertisement, file has been lost, but is there any reference, any document from which we can gather that there was an advertisement or a selection process?
The file in which there was an advertisement.
Mr. Counsel, had there been any selection process,
Yes.
had there been any advertisement, that would have been mentioned in your engagement letter. It is not mentioned. So your initial engagement itself was fraudulent.
My lord, to that, I say that actually a group of people are invited, allowed to participate in the interview.
Show us.
Any document anywhere, even that file.
I say, sir, I am appointed through 6 years in a sanctioned post and a group D post.
You see, you can say that. You can say, we have also to say something.
To that point, I may be allowed to read what I have said in my rejoinder.
Rejoinder.
Yes. In the previous return.
Oh, previous.
Petition. Okay.
Previous means the order which is under challenge or before.
No, in that writ petition, you had filed a rejoinder.
Yes. Clearly, I have stated that.
What have you stated?
On page number 3, paragraph 4. I have clearly stated that. I may be allowed to read that, only short paragraph.
Please read whatever you want. Read whatever you want.
Secondly, in the same paragraph, number 6, the counter affidavit, it has been stated that the post of cook-cum attendant was not created in letter number 10636 of SSD, dated 12/3/2007, and no advertisement was published for the post of cook-cum attendant in advertisement number 8. In this connection, it is clarified that the government letter dated 12/3/2007 at page number 41 of the writ petition had 29 posts of peons and peon at the rate of 15 per month was created. The breakup showing the aforesaid post is available in page number 42, serial number 33. We say that one post of peon class 4 was created under Faridapur Government High School in Koraput district. The petitioner was actually selected and appointed again the post, but wrongly in the appointment order in place of peon. The designation was wrongly recorded as cook-cum attendant, whereas no such post was available during that period, nor any recruitment was made for fill up the post of cook-cum attendant as per their own admission. They say that we have not recruited, we have not
Sir,
made.
this direction is contrary to the law laid down by Uma Devi. The Uma Devi's, there are two aspects. One, Uma Devi was delivered in 2006, and in Uma Devi, the court was considering appointments made prior to that so many years back.
Yes, yes.
And after, despite Uma Devi, your appointment is contrary to Article 14 and 16 without following any procedure.
My submission in this regard is.
And you are claiming regularization.
I have been appointed.
You have been illegally appointed without following any procedure for selection. That is enough. It is enough that you got the advantage for all those 15 years.
Point number 5, I am permitted to raise that one. The petitioner claims in support of RTI information received on letter number 8, which clearly states that no post of CCA was created by letter number this. Further, they have meticulously stated that the
Mr. Counsel, we accept your submission for the purpose of post sanction.
Yes, I'm
been
interviewed for that also.
Interviewed.
Yes.
So interviewed, whether only you were interviewed or some other
group of people.
Group of people.
Yes.
How many?
Around 6 and 7 people are there.
Around 6 and 7. How did they come?
It was advertised in the school.
Advertised in the school.
It was advertised in the school notice board. They all came together. There was a regular interview for them. The ADM and the
See, we are thinking of direction to the authorities to initiate disciplinary proceedings against such persons who are appointing people without following the procedure prescribed. Any appointment, even we cannot appoint a peon in the High Court without advertisement. What are you talking? Where is the question of regularization? It's a case of disciplinary proceeding against the officer who appointed you. Who appointed you? We are seeking a so-called in the present proceeding. Where is the appointment letter?
The appointment letter is that is page number 43 of the writ application. It is issued by District Welfare Officer for appeal.
All right, it should be taken to task.
It is the collector.
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 All right. So we will issue a general direction to the Chief Secretary that in all such matters should be inquired into, and the persons who have appointed people without following the procedure, they should be proceeded against. They are generating litigation. Unnecessary. Contractual appointment without procedure, then regularization. Third and counsel appearing on behalf of the appearing on behalf of the state of Odisha, the appellant, and so and so. Let this case for orders on Monday next. We will dictate order in the court.
I have been working since last 15 years.
You may be working since 45 years. You are going to take the employment of a gazetted officer. Because of your appointment, someone may be dismissed. You will direct the Chief Secretary to inquire into the conduct of the person who appointed you. This is happening even after Uma Devi. Please caution, please tell your Chief Secretary that this is the order which we intend to pass. Any appointment made without any process of any selection process after Uma Devi, they will have to initiate proceeding. This is generating unnecessary litigation. Yes, next.
Item 9.
The Advocate General to come and address the
So what is this? Yes, why?
Your Lordship.
SEBC.
Yes. Generally,
As Your Lordship, 2008, that has been declared as ultra-virus. First by the tribunal and has been upheld by the conservative division of the family court and is pending in an SLP.
What has been held ultra-virus?
Because it reached the 50% reservation mark benchmark. After that, there was a notification by the government of Orissa where they reduced the a percentage of reservation for SEBC to 11.25%, Your Lordship. Now, the reservation in the state of Orissa by the government of Orissa is for SC, ST, and SEBC, Your Lordship. Yes, Your Lordship.
So, see,
and the rule,
Madam, OBC
yes, Your Lordship,
is nothing but the class which is beyond SC and ST entitled for reservation.
Lordship, we have We have a commission, we have created a commission for other backward classes, Your Lordship. The census is being conducted, Your Lordship, but the state government has not come up with a notification naming the classes which will come under the OBC, Your Lordship. As of today, the state
OBC
government
is
doesn't-
SEBC, madam.
And Your Lordship,
You call it in whatever name, all classes entitled for reservation.
Yes, Your Lordship.
Beyond SC, ST, they are OBC.
The rules, Your Lordship, of scheduled tribes and scheduled castes, development, minorities and backward classes welfare department, Your Lordship, that was notified on January 6th of 2024. There we have two separate forms, Your Lordship. One for SEBC, Your Lordship, and the other for OBC.
No,
State
it cannot.
government, Your Lordship, we have.
See, there can be classification amongst OBC, like economically better.
Form C, Your Lordship, at page 15.
But in any case, SEBC cannot be
Form C is for SEBC, Your Lordship. And Your Lordship, at page 25 is Form B, that is for OBC. As for the central list, where the state doesn't have a list as of now. The census has been carried out, Your Lordship.
form.
C is for SEBC, Your Lordship, at page 15.
Yes.
And Your Lordship, at page 25 is Form B, that is for other backward classes, OBC in the state of Odisha.
25.
Yes, Your Lordship. Page 25.
What about the Act of 2009?
The Dismissal Act, Your Lordship, has been held to be.
2008.
2009, Your Lordship.
Yes, that 2008.
2008, that is held. to be.
Yes, the notification of 2009. Ultra-virus.
Very good, Supreme Court, Your Lordship.
Ultra-virus by which judgment?
By judgment of the tribunal, which was upheld by the division bench of the council.
It must be to the extent it transgresses 50%.
Yes, Your Lordship.
50% quota has been exceeded.
Because the
Thereof it was declared.
Indra-Swami judgment, Your Lordship, I would say that the reservation should be 50% freedom should be there.
During pendency of the SLP before the among affected, the state has decided to make it 11.25.
All right. Do you have this Odisha reservation of posts and services?
Well,
Has been- That has been said to be
then we have
otherwise.
some and backward classes regulation of response and verification of.
Just a minute. Just a minute.
This is the gadget notification after the judgment passed by the, they said that 11.25% to SEBC.
No, we want to see this Odisha reservation of post services. And then
Section 2E. Of that Odisha reservation.
This is the reservation policy by the Higher Education Department, the election of the government of Odisha.
Yes, so this.
you have Odisha State Commission of Backward Classes Act.
Yes, Your Lordship. 1993.
Being pendency, we should this notification. How वाला?
Act cannot. No, entire act cannot.
Oh, sorry, the reservation to the extent of 27% plus interest.
That was solution actually.
Commission under this act formed under this act, the lordship is still carrying out the classes of OBCs in the state lordship. It has not been notified yet, the list of OBCs.
So the notification reserving 27%, that was set aside.
The act
Act is there.
No, otherwise, the act has been,
The notification.
so lordship, but it is for SEBC.
Exactly.
The state.
So you had
doesn't
published
have an
20
OBC list, and the census is being carried out, your lordship. Census to include, different, classes as OBC is being carried out, your lordship, that has not been notified yet. Bihar has completed and state of Odisha
State
has,
has,
nearing completion of the, census, carrying out the exercise of census. But it is yet to be notified. We have a list for SEBCs and we are giving resolutions of 11.25% to candidates belonging to those lists. SEBCs.
Those can OBC.
So the tribunal had the jurisdiction to declare statutory provision illegal.
This High Court. In 1994, they come up with a notification which was quashed. So thereafter, they will come up with the act for which it was illegal. Same thing. Everything. Constitution of the Commission, I think. Constitution of the Commission, 1993.
See, this is what I was observing. See this definition. of backward classes in 1993 Act.
Thank you, Lordship. Is that for the purpose of this act means such backward classes of citizens other than the scheduled castes and scheduled tribes as may be specified by the state government in the list.
All right. So other than SC/ST, the classes which are, and then see the definition of socially and educationally backward class in here. In this act.
Backward classes as defined in clause A of section 2 of the Orissa State Commission for Backward Classes Act 19.
All right, we'll take up. Please give us the enactments and we can adjourn the matter for when will he
25th,
be available?
26th,
Huh?
26th of November, you know.
Whole entire week.
Counseling will be 30th November. Something last day of the council.
Then you will have to do something.
25th, 80 is going to be there.
No, counseling is beginning.
No, 30.
The admission is going to over by 30th of November.
No, then you will have to make some arrangements. We will take up the matter tomorrow. In the meanwhile, talk to him and make some alternative arrangement because this is also very important.
On Wednesday, you know.
On Wednesday. This matter on Wednesday to be within first 5 cases.
Oh, you're actually put on Thursday. My president, the Advocate General has.
All right, Thursday.
Kindly pardon me.
But in the meanwhile, you please give us the bare acts and relevant notification.
Kindly pardon me, my lord.
The compilation with the index list.
Yes, Mr. Rao.
Kindly pardon me, my lord. If your lordships may kindly permit me.
Yes.
Due to technical glitch, my lord, I could not mention one matter, my lord, at 10:30. If your lordships may permit me to, I have already given the mentioning memo to the.
Send your slip.
My lord, I have given it, my lord, for tomorrow, my lords.
Article 32. Settlement, now settlement is going on.
We will check.
I mean, pardon me.
I can send your lordship if your lordship.
Look at the file and
I may need to file a download affidavit. I don't.
All right, in the second half. Senior token is what?
Sarda Mines Private Limited, Lord Senior Counsel, Mr. Gopal Jain is appearing in this matter.
Mr. Counsel, we will adjourn. But just think of our embarrassments. There is a Supreme Court order passed in June 2023 that this writ petition should be disposed of within 6 months. And we have just been adjourning the matters on several dates. It's very, very embarrassing.
I understand. Last chance, as a matter of last chance.
As a matter of last chance, in fact,
2 weeks.
see, we need to restrict the orders passed by Supreme Court. Everyone, not only the court, you. So just talk to the Advocate General before we fix a date.
I have already talked, my lord. He has specifically stated that this time he will be present before your lordship and address your lordship.
Please conclude it. Otherwise it is very.
My lord,
it is too embarrassing for the court to adjourn, keep on adjourning. Just let us see. It will be. See, the court may be ridiculed. Let's see, there is an order of the Supreme Court and the court is adjourning the matter.
Extremely sorry for the inconvenience, my lord, for the last chance is not available. The last chance kindly consider. 212, because 2 weeks falls on 212.
Petitioner has been adjourned.
No, whosoever.
Last
Well,
chance, not a question of last
whosoever.
chance.
No party should. Otherwise you are frustrating the order passed by the Supreme Court. And the Supreme Court set aside the order or interim order.
I have already communicated the learned advocate general regarding all this.
What things?
What thing that honorable court
What
wants-
we are just
want-
saying, you have already
No.
communicated.
Honorable court wants to hear both the sides and for early disposal of the matter. Therefore, specific date honorable court desires to take note.
The specific dates are being fixed all the time.
Yes, therefore 2 weeks he has communicated to me.
2 weeks.
2 weeks.
He's going to remain in Delhi for 2 weeks.
No, Delhi not.
Have you, Mr.
Yes, I have.
Have you talked to your senior?
Because they informed us 2 days back that.
Oh, please be sure. Next time,
We have
it will rather be impossible for us to adjourn.
May I clarify, I don't, on the records would show that we have never taken time.
No, records would show you have taken time, but what is the reason? That is different. Records show you have taken time 4 times.
That was for counter.
Yeah, maybe. So when you say records show you've taken times 4 times, but what it was for, that is not there.
Because those
Yes.
are for pleadings to be. May kindly see.
No, so why go into that and waste time? Just fix a date. There was no interim order for 4-5 dates, but on last date you prayed for an interim order.
What is
We checked and found that the Supreme Court has vacated that interim order.
No, last occasion, your lordship has said that.
Yes, we said it, but before that there was no interim order for 4 dates.
Well,
So it was not fair of you to ask for an extension of the interim order. There was no necessity. What date can we fix?
You'll have to justify.
In this date was taken time thereafter. Probably maybe they didn't have the copy or something.
may I only clarify that, my lord, my instructions are the Supreme Court has not vacated any interim orders.
See, there was no interim order.
No, my lord, may kindly see order number 2, order dated 26/4/2021. There, my lord, interim order was subject to deposit. That has been done.
That has been set aside. The order has been set aside to the extent it was observed that payment of that amount, the hearing of this case will be subject to payment of that amount. Let's see the order of the Supreme Court. Therefore, last time we observed that any interim order, subsisting interim order shall continue. If there is some interim order which is subsisting, that shall continue.
Yes, madam, that is the point. There was an issue about royalty and DMF EMF. Royalty has been stayed. It's still subsisting today.
So far as direction imposed by the High Court to deposit an amount as precondition for hearing the matter is concerned, the same is set aside. So therefore, we observed last time that any subsisting interim order that today an adjournment is being sought on the ground of unavailability of sought on behalf of the opposite parties on the ground of unavailability of Mr. Acharya, learned Advocate General, because his presence is required in Supreme Court. From adjournment 2 weeks. it may be noted that Supreme Court, by an order dated 24/1/2023, passed in Civil Appeal number 514 of 2023, has requested this court to hear and decide the writ petition, this writ petition as expeditiously as possible, and in any case within a period of 6 months from today. So stop. It is unfortunate that for some reason or the other, the writ petition could not be taken up and finally heard. So stop. However, considering the importance of the legal issue involved in the present case, by way of last indulgence, the adjournment sought for is granted. So stop. List this matter on. Give us a date.
No, this is 2nd of December, Madam.
2nd of December.
2/12/2024 to be taken up at 10:30 a.m.
Okay.
So stop. We make it clear that no further adjournment shall be granted in view of the specific order passed by the Supreme Court as noted above. So stop. Next, in the meanwhile, the subsisting interim order shall continue.
Much grateful, Your Lordship.
Make it 10:30 or 12?
No.
Open matters will be there, this will take time.
All right, at 12.
May I only say 2 p.m. because it was being fixed at 2 p.m. So I had taken instruction for 2 p.m. Madam, if it's fine with your Lordship.
So if, all right, 2 p.m.
If it's not, give your blessing.
Item 37.
Is there alternative query for grant of that query lease law? You have to take an instruction.
I have received instruction, and in the meanwhile, while Lordship directed us to consider an alternative side, that was in the process. In the midst, they have applied for a new query. So that is, we are considering, my Lord. I have received instruction that my Lord, feasibility study and preparation of mining plan is under progress with respect to Rahatpur BSQ. In addition to this, the DFO Cuttack Forest Division has been requested to verify the DLC forest status and issue necessary NOC with respect to the query. This office has utmost care and respect towards the Honorable Court's order. So far as National Highway construction is concerned, this office will take expeditious steps for allocation of query in favor of the petitioner following due process and obtaining statutory clearance at the earliest.
Right.
Some time may be granted.
Some time, how much?
At least will not.
In the statutory clearance pollution control board, once they identify the query, we will get it. We have to apply the.
So you have applied already?
Already.
I have applied for grant of query. They have now, it seems they have agreed, Rahatpur. They have, it seems they have agreed and is preparing a mining plan.
Once they make the mining plan available to us, we will move the state pollution control board and they will go for a state environment impact authority. So that will take time, but let them clearly say that yes, it is given so that
in public interest, we'll keep the matter pending.
Yeah.
All right.
I think
So that in the meanwhile, the things are expedited.
Yes,
Huh?
my lord. We will take expedited steps.
Otherwise, you want to say that.
Would you
Then
accept the refer
Ask
this
for-
communication will not. Lordship.
We will proceed from there.
Last two para. No, last but two para. Last but two.
In the light of this court's order dated 4/11/2024, उसको काट लें. By order dated 4/11/2024, considering peculiar facts and circumstances of the present case, this court had directed the state authorities to come out with specific proposal for allocating an alternative site in favor of the petitioner for fixing its blackstone quarry. Stop. In compliance of the said order, Learn AGA appearing on behalf of the estate based on instructions, written instructions which he has received from the office of the Deputy Director of Mines, Jajpur Circle, has submitted that the petitioner has applied for an alternative query, Rahatpur under Dharmsala Tahsil of Jajpur district, a feasibility study, Rahatpur BSQ 25 acre, BSQ 25 SE. Feasibility study and preparation of mining plan is underway with respect to the said query. Stop. The DFO, Cuttack Forest Division has been requested to verify DLC/forest status and issue necessary NOC with respect to the query. Stop. Next, he submits that as the matter involves public interest and concerns construction of national highway, the opposite parties shall take expeditious steps for allocation of query in the petitioner's favor following due process procedure and obtaining statutory clearances at the earliest. Stop. In view of the stand which has been taken on behalf of the opposite parties, list this matter on 4 weeks.
My lord.
2
weeks.
2 weeks.
Reasonable. 4 weeks will be reasonable.
2 weeks, all right, 2 weeks. Let us, we will not insist upon.
So that you tell us what is the development,
Yes,
you
yes.
tell us on the next day.
I'll be there.
Yes.
To inform this court about further development in the aforesaid direction. Yes.
Will be given a little bit indulgence.
What?
Another item number 28. In that case, I have filed appearance from, I was going to give, I think, a comprehensive affidavit is necessary on behalf of the petitioner because nothing much is intelligible from the written.
Ask someone to be here when the matter is called.
I am here.
Why are you here? When?
I have no other case, that is why I mentioned.
He's saying he has no other work, so he will sit here.
All right. Because
Observe.
No, today I have no other engagement.
all right.
Very good.
Better sit here.
Adjourn by 2 weeks. 2 weeks.
Which?
Let the matter be called.
Oh,
We will adjourn in any case.
Let's see what it is, because you filed the counter. Rejoinder has also been filed.
But then seek to file an additional affidavit.
We'll see.
Reading of the counter and rejoinder together, I don't think one of the points that has to be made has not been made out. So, require some time.
Item 40, sought for leave of your lordship. Your lordship had granted me leave to maintain it.
42 is what?
42 is morning, we had mentioned the tender matter where the British work order is not being issued despite the petitioner being a successful.
No, that is not very urgent.
But what the tender period is getting over, has got over. So, what happens is that every time it is being re-tendered, the prices are going up. The bid prices are going up. In fact, apart from the loss that I am suffering, being not able to do the work, it's a tax on the state exchequer also. Because
The matter is not that urgent that it should be taken up out of turn. Your matter may be taken up today, we don't know after some time. Let us.
Can you not fix it to tomorrow?
Let us see. We'll fix. Let us see.
At 2 p.m.
Let us see.
Case admission item number 10.
When your lordship, you're going to file the affidavit today itself, your lordship. Next week, we are free for next week.
You are filing affidavit.
Today, your lordship.
London AGA states that we shall be filing a counter affidavit on behalf of the respondent in the course of the day. So list this matter on 1 week. So in the meanwhile, learned counsel for the petitioner shall be at liberty to file a response to this counter affidavit in the meanwhile. Yes.
Item 11.
Petition in action of party number 2, not consider the grievance of the petitioner in function of drinking water supply project under the scheme of Vasudha Yojana. The petition pending under Annex 1C, page 10, my lord, before the collector body. The petition only representation pending before the collector body.
A representation we will not do. Let us see what is the
Supply of drinking water by village Akhana and Katta.
yes, whether affidavit has been filed by Tahsildar.
My lord, I have already taken instruction telephonically, and they have claimed 2 villages are not supplied with the drinking water. My lord. My instruction is the first village, that is Akana.
Yes.
All the villagers are supplied to the making matter, and the second village, they are
So
going.
it must be difficult for Tahsildar to file an affidavit. Therefore, he is giving instructions on form.
Let's see me take up this matter next week. I will file it.
Come up for the first.
No, no.
We don't do not know, affidavit not issued.
No, no.
Order, sir.
This is WPC 23267.
2435.
Sorry.
24350.
24350. Yes, what do you want? What do you want, Mr.?
My lord, representation pending before the collector.
The representation, forget.
You also get instructions later.
Page 10.
4 weeks time is allowed for the opposite parties. Huh?
You already got instructions?
Telephonic instruction I have got.
No, not telephoning. In order to submit before the court. Telephone you can't submit before
Let's
the
see,
court.
keep it to next.
It has to be in writing.
Meantime, I will file it.
And who is this Gauri Shankar Sura? Who is Gauri Shankar Sura?
Number
8.
Gauri Shankar Shura, the contractor.
Contractor?
My lord,
What is he doing or not doing?
project from contract.
Effective steps against the contractor.
So we are junior engineers.
It has been sanctioned since 3 years and they are not even drinking water. Uh-huh.
Already one village is given.
Not
File your
question of
affidavit.
piecemeal. Both have to be question of drinking water.
For
2 weeks.
Huh?
2 weeks you can file. You got the instruction.
2 weeks time is allowed for the for AGA to file counter affidavit on behalf of the contractor. Contract is between whom?
Okay.
The block development officer will file the affidavit. Opposite party number 3.
On behalf of opposite parties number 124, 125. 125. Yes.
Item 12. 12 is the nursing matter where medical application was not been given at the time of inspection. Now he has already submitted. We will consider that application later for inspection and
Inspection has already been conducted, Lordship. As to DI requirement, page number 42. Running page number 42. The authority is demanded that you have to provide such these documents, and I have provided on time with on 24/6/2024. That is at Annex 7, page 43. Yeah, that be considered that I have already provided.
and similar matters, because most of the lot of cases are fine. My lord has given an order as per our submission that the institutions which have not been inspected, they will be inspected within 3 days so that they provide documents, except those who have not genuine fire certificate. That order can be passed for all the cases.
No, but whether he has fire certificate.
He has got only the application of that.
Then he says that everything has been complied with.
That can you dispose of that?
No, without our order also you are doing
We can,
inspection.
I can.
So we are not passing any orders.
I will.
You tell us what have we done.
Yes, yes.
So you are duty bound. In every case, you are not required to have orders on.
I will get these.
Discuss matter on 1 week within first 5 cases, so as to enable and counsel for the DMEP to inform this court about the status of the petitioner's application for grant of NOC or
Grant of renewal.
grant of NOC
Renewal or original?
Renewal.
for renewal of NOC. Yes. Item 13.
This matter, one more prayer to Roshan. The last admission date is on 30th of November. Can it be early?
You want it after we have kept it on
1 week.
25th?
1 week. In the meanwhile, do it.
Yes.
So in each and every case, they shall not pass order.
This matter, I know about
13.
This matter is squarely covered by your lordship order, this one, because as a matter of policy, the state government has stated that it was before your lordship their submission, and based upon their submission, your lordship had been pleased to dispose of that writ application on 29th order, and in the meantime, the state has issued a notification, considering the institutions which were not inspected at all, and my institution was not inspected. Annexure 5 is there, and they have to consider as per their own decision,
They will consider.
they are not considering without
They will consider.
Court,
They will consider. So where is the question of order?
it may be disposed of by your.
No, we will not dispose of like that.
Your lordship may kindly appreciate the last annexure. Your lordship may kindly appreciate the last annexure. That is the annexure. That is the letter.
You want us, Mr. Counsel, you want us to decide your case on the basis of what is there on record without seeking their response.
Millard, they have already taken time last occasion on 11.
Let us see.
Millard.
This is WPC 24568 2734.
From 13th. Okay. You've taken time on 11th.
Yes. Because he doesn't have a valid file certificate. That was the deficiency we had got. My lords has given a direction. Those who are having the valid file certificate will go for inspection of that. That is my submission. So if he has got the valid license, file certificate, who will inspector get the.
So there is no institute whom you have not inspected without valid fire.
Yes, ma'am. There are.
Yes. So do you have fire safety certificate?
You must kindly turn to annexure page 22, Millard. Millard, we have having the fire certificate, and as per the relaxation given by 2019 rule, Millard, our institution has been exempted. We have filed the documents. You will kindly appreciate. I have not annexed all of the documents, Millard.
So how will we appreciate if you have not filed the documents?
Millard, we have already filed these documents because that compliance is already there, Millard, under annexure 3, Millard.
Which item?
The item number, the top item. There are 3 items in this list, Millard.
Annexure 5. Where is your name?
My name is at page 22. You let me kindly turn to page 22.
Annexure 5, there are 5 items.
That I am placing item WBC number 27342 of 2024.
Fire safety certificate not complied.
Building plan
Without area details. Yes.
Then your lordship, I turn to your lordship. That notification is very important. Page 21 is important. Your lordship, kindly appreciate page 21. Page 21, your lordship, kindly appreciate. I am submitting just. I am just reading out for your lordship, kindly appreciate.
Rejection list of new
process before inspection. As a matter of policy, they have taken the decision on 29 October, Millard. Based upon their decision, your lordship has been pleased to pass that order. What order I have supplemented for your lordship?
Where is your name? Where is the name of this institute?
My institute name is 22 Millard, page 22. Trivedi Das Foundation Trust, Trivedi Academy of Medical Science, serial number 40, the top one in the box, Millard. 2 are my institution, 40 and 41, both are. And my 2 applications are before lordship, another is tagged up with that item, Millard.
What is your submission on this?
Millard, we have already complied with under annexure. My submission is that under annexure 3, we have already complied. You can appreciate page 19, Millard. and government has taken the decision, the institution which has not been inspected, Miller, they will inspect it within 3 days, Miller.
No, subject to the fact that you have fire safety certificate.
Miller, we are having the fire certificate.
Where is that?
Miller, we have having the fire certificate, your lordship may kindly, Annex 3, your lordship may kindly have a glance,
Let
Miller.
us see.
Page 19. Page 19.
19, that is the letter from the DMET.
Yes, ma'am.
Yes.
Miller, this is to the chairman, the nurses. 19 is the letter to the DMET, Miller.
Yes.
Then your lordship may kindly next annexure 20, Miller.
No,
My
no, this-
compliance, your
This is
lordship may kindly.
Annexure 3.
4, Miller. 20, page 20, turning page 20.
The following deficiencies are observed: fire safety, building plans.
Yes, Miller.
Yes.
All of the deficiency letter we have already complied with, Miller.
Where is that?
Page 20.
Where is that?
That is page 20, Miller.
Where is that page 20?
Miller, page 20 of my brief, Miller.
What?
That is my.
You have fire safety certificate.
Yes, Miller.
Where is your fire safety certificate?
You have said in that letter that online application.
Miller, that is.
Compliance is online application.
Miller, I am just reading out. Form B from DF.
Mr. Counsel, this is your stand that this institute has fire safety certificate.
Miller.
Where is the fire safety certificate?
Miller, your lordship can adjourn it to day after tomorrow. I will.
Very good.
Miller, it is with me, Miller. That is affidavit is with me. Your lordship can appreciate this affidavit, Miller. Miller, as per Miller, should I submit, Miller, one thing, Miller? Your lordship in various arguments through the previous occasions, Miller. 2019, there was an amendment in the fire safety rule, Miller. As per the amendment, those institutions which built up areas are less than 100 square meter, Miller, they are exempted from the purview of fire certificate, Miller, Form B. And our specific stand is that, Miller, our institution, as per the requirement, that is the built up area requirement as prescribed by the state government, is lesser than 1,000 square meter, Miller. And we are coming under that exemption. They can inspect it, Miller, to that
Mr.
extent.
Counsel, you should be clear about your own stand.
Miller.
Whether you have fire certificate, you don't have fire safety certificate, or you are not required to have fire safety certificate.
We are not required to have.
So why are you saying that?
That the fire safety people have to give that it is not required.
Yes, Miller.
Yes, so you have that
Yes, Miller. That is the affidavit we have submitted.
affidavit.
Yes, Miller.
My lord, page 15, he has given that 21,624 square feet areas, which is much more than 1,000 square meters.
Initially, when you started the institute, may have been whatever you are saying. Thereafter, if the size has increased, you have to give
See,
the
that is the
certificate.
ground on which your application has been rejected.
Miller, that is they have already taken as a matter of policy, Miller.
That fire safety is not required.
The fire certificate I am exempted. We are.
Mr. Das, if you are exempted, the fire officials will say that it is not required. So that certificate is required. What we have seen in other cases.
No, Miller. In many cases, I will satisfy your lordship, Miller.
Sir, are you sure? Why did you say repeatedly
That you have the
that
certificate.
you have the fire safety certificate?
Miller, fire safety certificate is not required for my institution.
Mr. Das.
I could not.
How can we?
So I am extremely sorry.
How you can be so irresponsible in your statement?
Miller, I could not follow that.
Follow you mean we are.
I am begging my apology because I could not follow properly.
No, you are very clear in your stand that you have affidavit, fire safety certificate is there in your file. You can show that. You are not showing because that is not on record.
Because as per their own notification.
Sir, make that submission.
Miller, that is not fire certificate.
No, sir, it's all right. It's all right.
We are exempted.
Yes, all right, exempted.
The
Before
CMET has rejected, has declined to inspect the petitioner institute for the grant of NOC to run nursing course, in the absence of fire safety certificate. Learned counsel appearing on behalf of the petitioner has submitted that the petitioner does not, if petitioner is exempted from the requirement of submission of fire safety certificate. So we are prima facie not satisfied with the submission which is being advanced on behalf of the petitioner. So this matter 1 week. So petitioner shall be at liberty to file additional affidavit to in support of the submission that the institute does not require fire safety. The institute is exempted from the requirement of having a fire safety certificate. Yes, 1 week.
Yes. Fixable date so that I can.
Date is always fixed. 1 week means 1 week.
WPC 25445.
See, Jagannath, immediately he had to file a writ petition and have given the number and to 19066 of 2024. He withdrew the case when the matter was taken up. And again, he filed a discase for recall of the order and he has filed this another petition, same petition, there and same thing, madam.
Your Lordship, may I
You must have explained why he withdrew that.
why I filed a separate date application, the subsequent date application, but Pharmacy Council of India has approved my academic session for
$5.45.
Yes, Your Lordship.
Yes.
PCI has approved my academic session for the year 2024-25, and that is at the date of 10, Your Lordship. Page 59. PCI is the parenting body and it governs all the institution of who are imparting pharmacy courses. Now, PCI has issued this approval for the academic session 2024-25 on 4th September 2024, Your Lordship. That is at page 59. For the subsequent, if PCI has approved my institution, have approved given the approval for the academic session 2024-25, then DMT cannot deny my institution.
When did you withdraw the petition?
I withdraw the writ application on Your Lordship.
Both the orders and the withdrawal and
23/9/2024. Your Lordship.
This was after this 4/9/2024.
I'm giving the withdrawal order immediately.
Your Lordship. I withdraw the writ application 28/2024.
Yes. So in August 2024.
Your Lordship. And there, Your Lordship, Lordship has categorically explained that it goes in running page 63, Your Lordship.
NOC.
And page 63, Your Lordship. At annexure 11, Your Lordship.
So in your modification, you had been granted liberty to approach the appropriate forum in relation to any fresh grievance not dealt with in the said writ application.
Where is it?
At annexure 11, Your Lordship. Page 63.
What is that, page 59?
Page 59, PCA has given the approval.
So what is the effect?
Your Lordship, PCA
PCI is the statutory body of pharmacy, the college institution who are imparting pharmacy education. Now PCI is the statutory, PCI has given the approval for the academic session 2024-25.
Under which provision?
Under section 12 of PCI Act.
Let us see.
Your Lordship. And there is a judgment of another bench of High Court, and Allahabad High Court bench, in particularly on this aspect, Your Lordship. But it's a single bench judgment. It has not been assessed.
Let us see.
Your Lordship. May I?
Yes.
Para 31, Your Lordship.
Yes.
The state government or the board at the most can make view opinions report to the PCI. And in such a situation, the PCI is only the statutory authority which can take decision on the report of the state government or the board. There is a question concerning this aspect, that whether the state government can deny the NOC. Referred to herein above is answered in favor of the petitioner institution that the state government or the board has no power to cancel the NOC. Granted earlier, as the power to cancel the NOC is vested with the PCI.
Then don't apply.
But
PCI is to grant NOC, why applying to this?
But again, there is a guidelines which mandates that we have to apply 6/4/2021 guideline issued by DME. And for that, after the renewal of NOC, then we can get the affiliation from the State Board of Pharmacy.
Page 49, our deficiency we have found 5 certificate. So that would
No, that is not the question. The question is that once a statutory body PCI has granted approval, can you deny grant of NOC? That is the question.
he has to produce our NOC before the PCI or clearance. Because once there is no.
So under which provision, we will have to readdress the issue.
Section 16 provides, Section 16 of PCI Act provides inspection. Central authority will inspect the college. And after the inspection, the central committee have approved.
See, it appears that this is like AICTE. So once they grant NOC, the examining bodies have a duty to grant affiliation or whatever for the purpose of examination. So whether this is similar to that.
Your Lordship, I will again.
Section
12, Your Lordship, for approval. Section 16 is inspection.
Which provision are you referring to, Mr. Rao?
Section 12 of Pharmacy. Pharmacy.
The Constitution of the state.
So have you furnished this information to the
Your Lordship.
DMET?
Your Lordship.
File your affidavit.
Yes, ma'am.
You'll see, because withdrawal has no meaning. Before withdrawal, they did not have this approval by the PCI. So now they have. And this once it is approved, says section 1, subsection 1. Subsection 2, any authority in a state which holds an examination in pharmacy.
So that authority, does it mean the authority under the state or this institution?
Authority in the state, not the state.
So the state has to approve, not the institution. Any authority in a state which conducts a course of study.
So 12 is something else.
All the approval process which has been initiated by the Pharmacy Council of India is under section 12, Your Worship, and after 12 is 16.
No. See, 12 is something else. 12 applies to the authorities in a state which conducts a course of study for pharmacists.
So that course has to be approved by the Pharmacy Council.
Your Worship, extension of approval also we have to make an application.
No, you are not an authority.
Your Worship.
So where have they granted you approval under section 12?
Page 42, Your Worship.
Page 42.
Your Worship.
59.
Your Worship.
This is under which provision?
Under section 12, Your Worship.
Where is it written?
I'll provide a guidelines, Your Worship. I'll provide a guideline.
Plus this case 1 week.
Subject to inspection.
Inspection has been
Subject to inspection throughout the year.
Your Worship.
This extension of approval,
Inspection is,
everything subject to inspection. So this is what they want, inspection.
Your Worship, that is for section 13. They can withdraw the approval.
See, we'll have to see the meaning of authority under section 12.
Your Worship.
Authority means the authority of the estate, or authority means any institute which is established by a private person. As requested on behalf of petitioner, is this matter on 1 week.
WPC 27356.
Can I request, can I make a question also? Can I be in top 5?
Top 10 cases. In the meanwhile, you also see this.
That matter also stands on the same footing of the first one which your lordship has been paid to pass regard. It may be adjourned to next week.
That's it for me.
13 sub-item number 1 is linked with that sub-item number 1.
Yes. So item 1.
For admission, item number 28.
So sub-item 3 is the same.
Yes, the 3 is linked with sub-item 1.
One.
Same issue, Miller. Exact
Okay.
college are same, only streams are different. Streams are different.
Both 25.
ANM and GNM.
To be listed separately.
They're not listed.
Item 28.
28 was the matter I was mentioning.
So what do you want?
I want an adjournment because
Council.
in the agenda only it has been stated that in reply to paragraph 1 to 12 of the counter affidavit, this deponent denies each and every allegation.
In fact,
That is neither here nor there. So
I am going to suggest State Bar Council people to have this continuing legal education system. Then I may request you to at least on the pleadings. It's very important.
You must answer then, and when I went to it, in the counter, they make out a positive case. You have to come out with facts.
Yes.
Hey, 1 to 2 are not correct, denied. Whatever is not admitted is deemed to have been denied.
Yes, you'll have to tell your juniors. This requested by senior counsel appearing on behalf of the petitioner, list this matter on 2 weeks. So as to enable the petitioner to file
A detailed
a detailed affidavit in support of his case.
On response to the counter.
Additional.
authorize the counter.
Yes.
Will result in dismissal of the
We may require to respond to that.
Go on and on and on.
All right. Do it, Wills.
Item 29.
In 29, my lordship, before my donation begins, I have a small prayer, lordship, I plan to, with 2 days time, I need to file an additional affidavit in this. 2 days time.
These are the same matters as your lordship remembers last week. Your lordship had heard a matter wherein these are all query leases, Blackstone query, where they did an auction. I was the highest bidder at X price. After that, all procedure was completed, they did a lease. While continuation, the auction was for 5 years, but each lease is given for a yearly basis. While the first year lease was continuing, they gave me a demand that the X has now become X plus 20, unilaterally. Now they have also filed a counter here. Counter, the only ground they have taken that because a high committee has been formed, committee asked us to do this much amount, we have given you this much amount. My lord, may kindly see the last order. I don't stand on the way.
So
My lord, kindly see the last
same
order.
problem as the previous case. Proper affidavit has not been filed.
No, but here and counter affidavit has been filed. My lord, may kindly see the
They're
last
also
order.
filed, but not.
May I state, my lord, may I only, the order is dated
Yes, 2 days
28
time.
to 2024.
All right, it will come after 2 days.
On 2 days, let us find.
Well, as well, sir. Well, specifically.
As requested on behalf of the opposite parties, list this matter on Wednesday,
No, Wednesday they have a personal difficulty.
Thursday.
Any interim order?
No, there's an interim order. Interim order. But same mallet that has already been complied with, 25% has been deposited.
So not necessary to extend.
Mallet kindly say to avoid conflict.
The interim order shall continue in the meantime. Interim order, if any, shall continue in the meantime.
Common.
A common order for all the matters.
Yes.
Wait.
Item number 30.
May I please well.
My lord, which recasting has been preferred against the order. After the order is immediate, your lordship will find the impugned judgment at Annexure 1. On the first date of admission, the writ was disposed of, directing us to regularize the services of the respondent. My lord, he claims in the writ petition, the respondent, that for the last 30 years he has been continuing. Actually, these are all incorrect facts. That what we have stated in the writ appeal now. He was sometimes in 2003, he was retraced again, once again came back in 2011. Those things he has not reflected those things. And continued as a work judge employee. Honorable Supreme Court in the case of Punjab State Electricity Board has said, observed that work judge employee constitute a distinct class. They cannot be compared. They cannot be equated with any other service patterns. There is also no scope for regularization since vacant posts are not there. Those things we could submit before the honorable single judge because it didn't get an opportunity. First date it was disposed of.
I go to one.
High Court of
Yes, we are setting that one.
But I thought you wanted to know. Because it was common order, this judgment was passed based on the common order, which has been passed in 200 and 300 cases. Because referring to the decision of the Umadevi case and Kesari decision, that since the workers have completed more than 10 years, they have been directed to be regularized. That is the case there.
But they had a right to say something.
Yes, ma'am. I will not look at it.
Page.
49.
Was there. The state of Odisha, in the present rate appeal, has put to challenge an order passed by a single judge of this court dated 38/2022, passed in WPC number 21336 of 2022. Stop. 2022, whereby the writ application filed by the respondent has been allowed with the following observation and direction, para 4 and 5. The writ petition was filed on when was that filed? 7/1/2023.
Yes, my lord.
Filed on
Oh, my lord. So, I won.
22.
17/8/2022.
no. It was number is 7/1/2023.
It's what?
21136.
21136 of 2022.
Acha.
Filed on 17/8/2022.
Filed on so and so 2000.
22. 17/8. Stamps are there. Petition also, let me check.
The 762, no?
Sorry, which?
The writ petition 762.
21136. Item 30. Item 30, WA 108.
In WPC 762, no?
762 is item 31, next one. This is the previous one.
Oh,
WBC 21136.
WS6, WA number?
WA number
10. Sorry.
filed on 17, disposed of on.
Bhakta Bandhu Shahu.
Yes.
Yes.
The writ petition was filed on 17/8/2022 and it was listed for admission for the first time on 30/8/2022. Stop. On the same day, the writ application came to be disposed of with the aforesaid direction. First off, 4 and 5 we have already put. Mr. Swansol and AGA appearing on behalf of the state has raised various issues as regards the factual aspects asserted in the writ application. Based on which only the learned single judge granted the relief which the petitioner had, the respondent had sought. First off,
Regularly should be regularized, positive action.
he has submitted that apparently the state was not given any opportunity to file its response to the averments made in the writ petition. Stop. He has drawn our attention to Rule 9 of Chapter 15 of the Rules of the High Court of Orissa 1948 to contain that it was incumbent upon that the opposite parties ought in the writ petition ought to have been given an opportunity to show cause against the relief sought for by the petitioner in the respondent in the writ petition. Stop. Learned counsel appearing on behalf of the respondent has submitted that taking into account the long period during which the respondent had served in work charge establishment,
What?
comma, the learned single judge rightly passed an order to regularize his services. Stop. Next. The settled rule that settled legal principle that if law requires an authority to do something in a particular manner, comma, that should be done in that manner alone or not at all applies in a proceeding under Article 226 of the Constitution of India also. Particularly when the High Court has laid down the rules concerning disposal of applications under Articles 226, 227, and 228 of the Constitution. Under Chapter 15 of the Rules 8 of the Constitution. The Chapter 15 of the Rules of the High Court of Orissa lays down the procedure for disposal of writ applications under Article 226 of the Constitution and states in paragraph in clause 9 as under. So stop. It is manifest on plain reading of clause 9 of Chapter 15 of the Rules of the High Court of Orissa that unless the court sees no sufficient cause to admit the application and rejects it, comma, notice of application is required to be served on all parties to the proceedings, quote unquote, to show cause by a date fixed. Full stop. In our considered view, comma, the court, a writ petition can be dismissed if dismissed, comma, in the light of clause 9 of Chapter 15 of the High Court rules, if no sufficient cause is found to admit the application. So stop. If however, application full stop. Otherwise, full stop. Otherwise, comma, the parties to the proceeding are required to be given opportunity to show cause by a date fixed. So stop. Barring exceptional circumstances, comma, the rule, the procedure prescribed under clause 9 of chapter 15 of the High Court rules cannot be ignored. So stop. On this sole solitary ground, the impugned order passed by the learned single judge deserves interference. Accordingly, order dated so and so, passed in so and so is set aside. The writ petition so and so restored to its original file to be placed before appropriate bench according to the assignment. Yes.
May I target it?
Appeal is allowed.
May I target it? My lord, may I target the case with it to be disposed of?
No, that we don't know. Tag it means other cases for disposal. That we cannot do.
Writ petition of the year?
22, but the person has already retired, suffering from getting pension.
Yes.
Item 31.
31 million on behalf of Mr. Dasmili, I will take up next week.
In this case, I am the appellant.
Respondent 1.
Have you filed any contempt?
That order is to stay because your logical issue notice on the question of limitation earlier. Limitation delay has been found out.
Oh, delay has been condoned, but have you filed any contempt petition?
My lord.
You have filed?
No.
Don't pursue.
Relying this judgment, many cases are disposed of in light of Manoj Raut's case.
28.
31.
31.
You file counter affidavit to the writ appeal?
Yes, filed.
Let's hold the dismiss.
That is the order?
Yes, ma'am. Order is there. Page 53, madam. Understood.
Next.
Ah,
Next support starts from page 51. Order starts from page 53.
save protection.
Yes, what is the point? He is seeking adjournment.
He is seeking adjournment.
1 week.
So let us grant him.
Yes, no, I don't object because only my prayer was that judgment is paid, my lord, because that relying this judgment, others are coming and cases are disputed in terms of this judgment. So that's why that I am saying, your lordship, fix it to next week. I don't have any objection to my lordship's prayer. For an interim, I am praying for an interim.
Interim we will grant only if we are satisfied.
Yes, ma'am.
He's saying showing disorder.
No, so 1 week, if within 1 week, so if the orders are passed, then nothing can be done. You can say that the appeal is being taken up.
Any next week?
As requested on behalf of the respondent, list this matter on 1 week. Tuesday, sir. Within first 5 cases.
Yes, okay.
Item 32.
Here, Mr. Behra. Mr. Behra.
Is Mr. There?
Mr. Jenna.
I'm appealing for the appeal in my lordship. There's a talks of
Previous one.
What are the studies? What are the process going on with it? For 2 weeks time so that it can be settled.
And then counsel appearing on behalf of the parties seek adjournment on the ground that the parties are in the process of getting the dispute resolved amicably. So, as requested, list this matter on 2 weeks.
33.
Why 2 weeks? Rejoinder. What is this matter about?
It's about the construction of a bus stand, your lordship. And bus stand has been constructed over the same place where the old bus stand stood, your lordship.
Is it a PIL?
Yes, your lordship. And they say a blockage of drain water. The drain by debris and all, it has been blocked, which the authorities are taking care to clean it, your lordship. And the construction is away 3 feet away from the drain, your lordship. You even annex photographs of the place, your lordship. Counsel affidavit.
Yes, what is your ground? What is your ground?
I'll take instruction, my lord, I will also handle 2 weeks after, my lord, I will file the revenue.
No, you are not required to file. You are required to satisfy us whether there is any merit or not.
So you are admitting that debris have blocked the drains?
Some part of it drain, and we are also admitting that we are cleaning it, your lordship. Para 6, your lordship, it said that the said drain is now covered with mud and the abyss, which I think the block administration is putting all effort to clear the abyss. But the construction is 3 feet away from the
No, but if you are blocking the drain, then
that is being cleaned, your lordship, by the authorities. We've taken
Litigation is getting
that it's been
affected.
cleaned. And
All right, as requested on behalf of
the old bus stand stood.
Krishna, list this matter on 2 weeks so as to enable him to file a rejoinder to the counter affidavit.
34.
Your lordship, we have received the counter from opposite parties 2, 3, and 4. We would like to file a rejoinder. Your lordship will kindly grant it 2 weeks.
2 weeks. Sorry, rejoinder.
Madam, you are,
Your lordship, I am for the petitioner.
name please.
Arpita Mahapatra.
Yes.
Item 35.
I have filed counter. I need some time to file a rejoinder.
Rejoinder. Yes.
Item 36.
36 is regarding that NOC. Instead of giving D pharma, NOC, we had given B pharma. Now I have instructed them to give to D pharma, not B pharma. I have instructed them that I will next week to come, I will get this.
As requested on behalf of DMET, there is this matter on Tuesday within first 5 cases so as to enable him to seek further instructions. Ensure that it is done in the meanwhile.
Yes.
38.
It, my lord, here, 2 deficiencies are there. My instruction is the principal will be present before the DMA with the documents. We will issue a motion.
So any order?
Like principal
to 21st, let it be produced before the DMT along with the principal and documents. We will consider for NOC.
So is there any order similar to that?
There was an order. I have-
There's an order of your lordships in a nursing college matter. If your lordship may.
I will give it my. I'll give.
My lawyer senior just showed me that. It's WPC number 15165 of 2024.
Pharmacy court.
Yes.
If your lordship may extend
Voice from the-
same order to pharmacy matters, you know, that will cover.
Voice from the-
Learned counsel appearing on behalf of the EMET submits that in the case of the petitioner's institution for grant of NOC for conducting B Pharma
Yes, ma'am.
B Pharma course
Fresh or renewal?
Freshman.
course shall be course
For the year 2024-25.
for the academic session 2024-25 shall be considered once the principal of the college appears before the
DMT
DMET
on 21st. 21st.
DMET by
21st of 11.
If your lordship may fix it by 25th because I'll have to get the certified copy of the order and inform the principal.
before the 21/11/2024. This is a team. 21 is 21.
Lord, if I may pray one thing, if your lordship may observe, there's annexure 10 where I have complied with the deficiency in time. On 18th, they have received it.
That they will decide.
Yes.
If the in such view of the matter, we should dispose it off. Huh? Should we dispose it off?
Yes, sir.
In such view of the matter, in view of the stand which has been taken by Mr. Mohanty, learned counsel for the DMET, this application stands disposed of.
39.
May I please? Lord, this is regarding the challenge to cancellation of a lease deed, quarry lease. In the demand notice. Lord should remember that, recollect that the question of jurisdiction of the authority which has passed the cancellation order is an issue apart from natural justice and other grounds.
Consolidated petition we have received, my lord. We seek 2 weeks time to file our response to the consolidated writ. And we will,
The authority doesn't have power under the amendment.
that is sole question, my lord. Because after the amendment. After the amendment, the sub-collector has had no jurisdiction pass the order. That specific instruction I have sought for, I will ensure that the instruction comes and I.
Some other instruction will come that he had the power to dispose of.
On that, my lord. They have to specifically. If
No, actually, my
the
lord,
power is not
I
there,
can
my lord,
appreciate the difficulty because there was a transition.
That order is a nullity, that order will be a nullity, and matter will be relegated before the competent authority for fresh disposal. That should be the order, my lord, but.
Yes, sir.
But I have to examine
You have to examine.
the amended provisions 1 week time.
What will he examine the amended act is there? Okay, examine.
I am seeing the file, just the consolidated application in the file, my lord. It has received. But Lordship may grant me.
The amendment application was there 2 weeks back.
Yes, 2 weeks.
Wednesday, you come on Wednesday. Question of law.
Wednesday.
As requested on behalf of the state, is this matter on
Sorry,
Wednesday.
item 39, I'm sorry. Not having-
Wednesday, he will decide. Wednesday, nothing for.
You are appearing for whom?
But I was in other court.
नहीं, question number 45.
You are appearing in another court, but you are appearing for whom?
3 to 5. OP 2, 3, 4, and for temple mirror.
So we'll take up on Wednesday.
Yes, tomorrow.
Item 40.
May I please, your lordship? I am for opposite party number 2, my lord. I have filed my wakalatnama. I filed the complaint. Looks time.
What is the case?
My lord, my deed has been cancelled, though listed as L1, but rejected on the ground that I am not published the power of attorney. For that reason, that is not mandatory, my lord. Your lordship knows the entire fact, my lord, I have mentioned earlier. Only I have not furnished the power of attorney for the, I have a single proprietorship part. It is not possible for my part to furnish the entire power of attorney. I have completed each and every criteria, and my bid has been selected as L1, but it has been cancelled on the ground that I have not furnished the power of attorney. There is no other person in my proprietorship.
No other?
No other person in my firm to whom I will supply the power of attorney. I have a single proprietorship.
Give it to somebody else also.
Madam?
Can be somebody else, an employee also.
But power of attorney.
No, I have a single proprietorship. No.
Power of attorney if you for the other side.
NSC is appearing, NSC.
Why power of attorney?
I am for the opposite party number 2.
Yes,
For NSC Bhanjanaba.
yes. The tender.
My lord.
You are the one who floated the tender and.
Yes, my lord. Yes, my lord. I will file the counter, my lord, within 2 weeks, my lord.
Why 2 weeks? You issued notice on 39.
I have uploaded Bokasnam, I have filed.
Yes.
I will file it. The tender is, it has been clearly mentioned in the
2 weeks time is allowed for the opposite party number 1 to file counter affidavit.
opposite party number
All right,
3.
party number.
Opposite party number 2.
May I submit the L2 has started his work, madam, there. L2 has started his their work, madam. I am the L1. I was earlier selected as L1, madam. Though my bid has been cancelled, though for that reason, they have awarded to L2, and L2 has started their work.
1 week, 1 week. You file counter within 1 week.
Again, my lord.
1 week.
To 41.
Lord, 41 is a nursing matter, my lord. Here, the defect is the fire certificate not produced. Fire safety certificate. And the building plan not submitted. I have filed the counter, but copy has not been served because you was not available.
Serve a copy.
And submitted come on next week.
Let a copy of the counter affidavit be served
By tomorrow.
on behalf of the petitioner by tomorrow. When?
By tomorrow.
In this case, 1 week.
Yes, ma'am.
Item 42.
Item 32, Willard. The Lordship passed order on 21/10/2024. That identical matter that Lordship has passed a judgment in Rosmetra Technologies Company that is relating to a tender condition to show the past litigation, Willard. Now today we are filing the counter affidavit. Lordship may take up this matter. Yeah, but today we are filing it.
No, what time was granted? So 1 week further time is allowed for the opposite parties to file counter affidavit.
Submission being noted is filing today.
In course of
Copy.
And AGA, and AGA appearing on behalf of the estates, on behalf of the estate submits that he shall be filing counter affidavit in course of the day. Have you served a copy?
They have not.
A copy of the said counter affidavit shall be served on learned counsel for the petitioner. So place this matter on 1 week.
Yes, sir.
So as to enable learned counsel for the petitioner to consider the said counter affidavit and file reply if so required.
Item 43.
So counter affidavit you file in the first one or the second one? Mr. Tripathi, file counter affidavit, first case.
In first case.
Yes, first, he list with the reason.
43.
My lord, in this application, my lord, lordship granted 2 weeks time to file our response, my lord. I seek further 2 weeks time, my lord, to file our response.
There is no representation on behalf of the petitioner. So,
I had communicated my lord and friend appearing for the other side. He also agrees to my
All right.
seeking time, my lord.
As requested on behalf of the petitioner, list this matter on 2 weeks on behalf of the opposite party.
I am for the state, my lord. Yes.
You are
State
speaking
is
at
opposite party.
Opposite
So you want to
requested on behalf
Yes,
of
yes,
the
yes.
opposite parties. List this matter on 2 weeks so as to enable him to file a counter affidavit.
You file it within 1 week, counter?
2 weeks time.
This is a matter in which they were seeking adjournment.
First, both.
Both were seeking adjournment.
No, both means the counter was seeking adjournment, both the matters. The 27 and this one. First same counts. They do it after that. You posted on the same day.
Mr.
Mahathir.
No, Mr. He was very keen on arguing that.
What was another? Yeah, only scheme.
What is it?
Interim audit to continue on. The last occasion your lordship have to put an interim audit till the next day and ask them to file a counter.
All right.